Court officer, sir. Court officer, sir.
My lord, I have a small submission to make. List number, cause list 3, list number 9, serial number 19. Tomorrow,
She will call the list.
my lord,
adjournment.
tomorrow matter is listed before district court. Awesome. Last, it came day before yesterday. Again, today they have put it out. Though office objection have been compelled, they have put it
No,
non-compliant.
the problem is, so many memos are given, I can't take any exception. That's why all the memos will be listed, and accordingly, whatever I can take up, I'll take up.
My request is that case is there tomorrow at Asan District Court. That's the reason I'm requesting, my lord.
What is, in which,
Serial number 19, cause list number 3.
$230?
Much obliged.
My lords.
My lords,
My lord.
All the memos to the court officer, no, nothing, you don't have to mention, they will be added to the list. That's what I've said.
Lords,
You didn't inform them, court officer? Take that.
page-wise adjournment, list.
my lords, the
Hmm?
Council submission is there,
Whatever it is, you give the memo, it will be listed, I will be,
listed on council submission.
huh?
On council submission only let it be listed, my lords, because it is, could not be, it cannot be compliant.
It will come, give it.
my lords, the matter is coming up before trial court tomorrow, my lords.
When is it posted? When is it filed?
Lords, today morning, my lords, because
You file it today morning and we have to take it today
the
itself?
order was passed on the last working day of,
Last working day is on which day?
we applied for certified copy, my lords, there was a delay.
I'll not take up like that. If it is there, we can see the day after tomorrow also. Let it come on Monday.
Page-wise adjournment, list number 1, page number 4. Page number 4, serial number 16 to 23. Page number 5, 24 to 25. List number 2, page 1, serial number 1 to 3. Page number 2, serial number 4 to 7. Page number 3, serial number 8 to 13. Page number 4, 14 to 18. Serial number 5, page number 5, 19 to 22.
Third list need not be called.
Let's, one submission. Lords. Thirdly, serial number 99. The lordships heard both the sides yesterday, my lords. It's on the deficit stamp duty paid. And only for a short clarification that the same council also made the submission that they're ready to pay stamp duty. It was agenda today. Could it be had tomorrow in the first list, my lords? It will not detain the court room.
Take it up at 2:30.
Please, my lords.
Serial number
99.
97.
List 399.
Serial number 97. Call list 3, madam. Filing withdrawal.
95. Take that
97.
memo.
97.
97.
Sorry. Each serial number 65, but I need to call agenda application, agenda. Serial number 3, serial number 44. Serial number 103. Posted. Yesterday they made a submission that they are going to receive one house. They have already constructed 3 houses. They are residing in it. In addition to that, they are constructing another house.
List number 3, 44 serial number. Kindly have it and
When it will come, last time, we don't get your response. Monday, there is only one response. Let it be the list. If there's no reason, yes.
Milad, serial number 1, Milad. Milad, serial number 1, Milad.
That is not your matter, Mr. Umesh. The memo is fetching to withdraw the petition. Dismissed as withdrawn. Yes, next.
2. Mallikarjun Swamy, yes.
Yes, same. Yes, 3.
Serial number 3.
Same. Memo is filed.
Serial number 4.
A memo is filed stating that the writ petition has become infructuous.
Serial number
Accordingly
5.
dismissed as infructuous.
Serial number 5.
Same, infructuous.
Serial number 6.
I appeal for the petitioner, my lady. The matter which it was challenged before in commercial court is settled, my lord. That therefore I filed a memo for withdrawal.
Same, the memo is filed stating that the dispute is settled before the commercial court. Hence, the petition has become infructuous, dismissed as infructuous.
Serial number
Great.
7. Serial number 7.
Dismissed, same, dismissed as withdrawn. Yes,
Serial number 8.
it's not infructuous, just say memo is filed seeking to withdraw the petition. Yes,
Serial number 8.
it's stated that a memo is filed stating that the parties have entered into a settlement, and in view of the settlement and receipt of the entire amount, petitioner does not want to prosecute the writ petition. Hence, the petition may be dismissed as withdrawn. Accordingly, the petition is
Serial number
dismissed as
9.
withdrawn.
Prepare for petitioner.
While in the withdrawal of the memo, one of the prayer has been satisfied. So I may be permitted to, seeking liberty to file the fresh petition.
You have sought two reliefs.
I am for the petitioner.
That's what I'm saying. You have sought two reliefs.
Yeah, so I have sought two leaves. One of the relief
Memo
has been
is filed
satisfied.
stating that in the present writ petition, two reliefs are sought. And during the pendency of the writ petition, one of the prayers mentioned in the writ petition is satisfied. Hence, the present memo is filed seeking to withdraw the writ petition with the liberty to file a fresh petition with regard to the other relief. Accordingly, the writ petition is dismissed with the liberty.
Much.
Yes,
Serial number 10.
There are two office objections, my lord. One is that the original defendant in the suit has not been made a party, my lord. Office, my lord, there is a note written. My lord, this is square only pertaining to the issue of court fee. My lord,
no. As per that, whoever are the parties, you have to mention them in the cause title, and you have to, there has to be a note saying that they're the, because
my lord,
it
I
is
will
not
do
a
that, my
proper
lord.
and necessary.
If my lord permits, I will add the name of the other defendant and seek dispensation of notice because at my risk, for the simple reason, my lord, this is a case where, my lord, I filed a suit for recovery of money. It's a joint development agreement, my lord, where I claim, my lord, that I have been defrauded of certain sums. I wanted my lord, attachment before judgment. Therefore, I my lord, sought my lord, dispensation of pre-institution mediation by filing an application under Section 12A of the Commercial Courts Act. Lord, the learned judge, my lord, he has, because mediation was not done before the institution of the suit, instead of, my lord, deferring or keeping the matter in abeyance if he is of the view that there was no such urgency, decided to, my lord, on the very first day, dismiss the suit under Order 7, Rule 11 and rejected the suit. because I have not gone for mediation. My lord, that is now covered, my lord, by judgment of the Honorable Supreme Court, which says that if court comes to the conclusion that there is no such urgency, my lord, keep it in abeyance and let the parties go for mediation. Now, my lord, after this, because I was running against limitation, I in fact instituted pre-mediation, my lord, the institution mediation, filed a suit. Now, my lord, in the meanwhile, because I had paid 4 lakhs and odd court fee on this, I asked for refund of the court fee. Court says, my lord, now that I have rejected the plaint, I will not refund the court fee to you. Lord, that is the predicament in which I am placed. Therefore, my lord, all that has to happen, my lord, is that that court fee has to be adjusted or refunded, and I have to repay. That is the situation. The reason, my lord, why I have approached this honorable court at this juncture is, my lord, unless I pay court fee on the other suit, my lord, my other suit will actual suit where I have done the pre-institution mediation, my lord, that will get dismissed.
Will you come to this order?
Order, my lord, page 25, no, page 32. Page 32, the order on the issue of court fee. All that the court has said is you have not instituted pre-institution mediation.
No, what the court did is only it has dismissed your application.
No, my lord, suit was dismissed,
No,
and consequently,
I'm looking at page 22.
22, my lord.
Consequently, the suit itself is rejected.
Suit itself is rejected. That is wrong, my lord. That anyway, my lord, I possibly cannot challenge this order for the simple reason that I would have run out of limitation. So I had to file a suit. I have done it. It is granted an FR number, but so far as court fee is concerned, my lord.
We get that.
The other suit.
No. With regard to the court fees and all.
Court fee, my lord. I filed an application for refund of court fee, my lord, which is at page 53. This has been rejected by order at page 32 of the order. Again, on the basis of 12A not having been complied, court says, my lord, it may not be a case where I can refund court fee to you because I rejected the plaint.
It is not return of the plaint, but it is a rejection of the plaint.
It should have returned the plaint. That would have been, my lord.
So unless and until you question that order of return order, and how can, there is no provision when the suit itself is rejected,
Lord,
that the plaintiff is entitled
correct.
for refund of the court fees.
That's true, my lord. That's the peculiar circumstances. My lord, I was able to lay my hands on Delhi judgment where similar situation arose, and courts have held, my lord, that the whole reason for this fiscal statute, such as a court fees act, is not to unnecessarily burden the litigant and deprive him of the court fee. And in such circumstances, my lord, it should be returned. I'm sorry, my lord, it's in landscape somehow. My lord, paragraph 10, my lord, in the second page. There the question was of jurisdiction, and my lord, on the question of jurisdiction, suit was rejected, saying that whether it's a commercial court or the other court. Lord, then, Lord, they say that in the case of Nagpur District Central Cooperative Bank, relied upon by the Learned Counsel for the appellant.
No, on just hearing the facts of it, it appears, it sounds good that it has to be done. The court fee has to be refunded, but wherever in all the cases of rejection of the plaint, whether the plaintiff is entitled to, because it is not an order pertaining to the facts of this case. It's a larger aspect where whenever a rejection of plaint is done, whether they are entitled for refund of the court fees is the question.
That is not. My lord may consider it. In the meanwhile, only my request, my lord, is that my other suit should not be dismissed, my lord, in the meanwhile. That's the only prayer I'm making.
Be dismissed in the meeting.
Because I have not been able to pay court fee on my,
But you can't, you have to pursue it. If you're entitled for a refund, you will get it. But we can't connect this suit to that suit. You have to pay it. And if you
I
will
don't have
succeed,
the-
if you will succeed in this, you will get, they will return the court fees. There will be a direction to return the court fees. But we can't connect both the suits.
Lord, unfortunately, my Lord, I'm in such a predicament that I may not be able to.
That's what we
again
will
pay the-
examine this issue.
Yes.
And what is the purpose, what is the purport of the act and what is to be achieved and what are the, the law on this. If you can assist the court, we will
Yes.
decide it.
Lord, in the meanwhile,
There
let that
can't
be.
be a, no. We
Lord,
can't mix
Kindly,
both.
kindly see the interim prayer that I have sought, my Lord, page 13. I have only sought stay further proceedings in my own suit. I have instituted, my Lord, otherwise, my Lord, that
You pay
court
the
will
court
reject
fees,
it.
You pay the court fees. If you are entitled for any refund, subject to the orders to be passed in this, you will be getting that amount.
Lord, for a short period, if it is, my Lord, stayed, I may be
can't
able
be-
to, my Lord,
Notice to the respondent. No respondent.
Lord,
Respond-
the one more
Because it is-
objection is that, my Lord, I have made principal senior civil judge as party. My Lord, if it's in Bangalore, my Lord, it's the registrar in whose name, my Lord, I take court fee. In other courts, my Lord, it's taken in the name of the principal, my Lord, senior civil judge. Therefore, my Lord, I had to make him a party, my Lord, to the proceedings I have mentioned in the note that I have written. That is the other.
Why is required?
Because court fee, he has to refund.
Ultimately, when an order is passed, it will be implemented. Don't have to, they need not be
Normally, we make
parties.
registrar a party, registrar of civil court, my Lord, whenever,
Objections to be complied with within 2 days. When do you want?
my Lord,
Hear it if you can assist the court.
anytime, my Lord.
List the matter on 23rd June. Yes. Yes, next.
Item number 11,
My Lord may consider in the meanwhile not to put
No,
me in a, I'm already, my Lord, in a very peculiar situation.
Pay the court fees if you are entitled, you will unnecessarily late. We can't mix it because, yes.
Lord, permit me, my Lord, to add the name of the pro forma defendant.
You,
And, my Lord, I will seek dispensation, my Lord, by filing a memo of notice.
no, but that's what I said. You can comply with the office objection. That's what they said also.
Then I have to file, unless my Lord, permits.
Petition is permitted to correct the cost item.
Yes.
Yes. Give it to them.
serial number
Grateful.
11, OPPN,
The office has taken objection with regard to the maintainability of the writ petition against an order passed on I number 5, invoice number 253 of 2025, where the petitioner has a the IA is filed under Order 7, Rule 11A, D of CPC, and that came to be rejected. Agreed thereby, the writ petition is filed. The court has raised objection with regard to the maintainability. Accordingly, the office objection is sustained and the petition is at liberty to convert this into a CRP. For the statistics purpose, the writ petition is dismissed. Yes, next.
serial number 12,
Lords, I appear for the
Akshay Kumar Jain.
petitioner. Lords, the office objection is the petitioner is not a party in the execution proceedings. My Lords, the difficulty is that the learned executing court is proceeding against my personal assets. Therefore, I have had to file this
What
petition.
you are supposed to do if the trial court is proceeding against your property?
My Lords, I have filed my detailed objections. In fact, this court has already remanded the matter for the executing court to decide whether I am liable for the assets of the company, I mean, for the liability of the company or not. In the meanwhile, decree holder files an application seeking disclosure of assets of the judgment debtor company. To the best of my knowledge, being the erstwhile director uh, and having been arrested in these proceedings earlier, I file whatever assets are in my knowledge. Thereafter, what happens is the executing court says, you keep him present for cross examination with respect to the assets of the JDR. I said, I'm willing to comply. My lords, however, the order, impugned order records, and this is the only issue I have with the order, it says with regard to the assets of the said person. Only to this limited extent I have to challenge, because there is no finding of fraud against me. There is no piercing of veil. They cannot proceed against me at the moment, at least.
All this you can raise before the executing court.
It was raised, my lord. There's a
Where is that idea? You're not a party. Where is the question of raising all this before the executing court?
Please, my lords. My lords, may please come to page number 81. I was already arrested in the matter. Therefore, I'm contesting this matter as a third party. Entire proceedings, it says.
You have been impleaded.
I have not been impleaded, my lord.
Then how are you contesting?
Well, it's because I was arrested. I have deposited money to secure my release. And when
What's the order? Let me understand what it is.
Please. Lords, may please come to page number 27.
Yes.
Third paragraph, my lords. Counsel for Tara Prasad Mohapatra is present and submits that he has submitted all relevant information to the best of his knowledge and ability, and undertakes to keep so and so present so that the other side counsel can conduct an inquiry with regard to the assets of the said person.
What is this I number 4?
My lords, IN number 4 is under Order 21, Rule 41, seeking a direction for the judgment debtor to disclose their assets. My lords, I was the director of the company as it then stood. Therefore, I contested the arbitration proceedings, 34 proceedings, all against me. I'm not for a minute saying I succeeded in those. Therefore, they are now proceeding against me.
And that apart, when you are not a party to the proceedings and you want to question a particular order, even otherwise, you have to seek the leave of the court. Straight away, you can't file a writ petition.
My lords, because there's already a direction against me, my lords. Note, my another difficulty is, my lord, the petitioner is no longer.
There is a difficulty, there is a procedure. You have to file an IA saying that you have to seek the permission of the court. Straight away, you can't file the writ petition. How will they number it? You are nowhere, you are a party to that.
My lords, if I may show the earlier petitions that were filed, such objections were not.
Help it. You have to come up with such office objections. The petition shall comply with the office objections.
Lords, can I request a date, my lords, because I have to be cross-examined on 9th. Can it be tomorrow?
At least to know the procedure. How will you file it?
My lord.
Is the matter on Tuesday? Yes. The petition shall comply with the office objections.
Cell number 13. Shankar Lingay Gowda for petitioner.
Kindly pass over, my lord. Regarding the maintainability of under section 21 rule 105 and 106.
Pass over. Yes,
Much
14.
Cell number 14.
Lords, I'm the petitioner. The only office objection, my lords.
This is a problem. Everybody seeks a memo and you don't comply with office objections, and all matters have to come like.
The only objection which is raised is that one writ petition has been filed for 2 IAs. The 2 IAs is recalling and reopening of cross of PW1. That's the only objection. I have written a note also. IA number 11 and 12 before the trial court was for recalling and reopening of cross of PW.
2 IAs still. There are 2 IAs you have filed.
Once, 2
orders are passed.
Once the order is recalled, the reopening is consequential. Separate WP would not maintain it.
For each case, we can't look at that.
It's a common order which has been passed.
There are so many difficulties when 2 IAs are questioned in one order.
Common order has been passed by the.
That's why some directions are issued to the registry not to number it, and for everything office objections, counsel's submission. Yes. Yes. Argue. What is the matter?
The IA number 11 and 12 has been dismissed by order dated.
Where is the order?
This order is at page 79, my lords.
Yes.
My lords, the reasoning is at page 82. Only two paras, my lords. Reason. Second para at para number.
It is of the year 2018. When was the evidence concluded?
My lords, evidence was concluded in 2023. This IA was also filed in 2023 itself. In the meanwhile, my lord, what has happened is I had filed an IA seeking to.
We'll read the order. It's a very short order.
Lords, page 82.
Yes,
Para 8 is the reasoning.
yes.
On perusal of evidence, both above witnesses shows that the counsel has already cross-examined in length and above witnesses for more than
Where
6.
are you reading?
Lords, page 82.
Read from para 7.
Lords, the present suit is filed by the plaintiff for relief of declaration and partition, and the case is posted for arguments. In the meantime, the present applications filed by the counsel for the defendant with a prayer to reopen the evidence on the plaintiff's sides and recall PW1 for the purpose of further cross-examination. The counsel for plaintiff has opposed the application, denying the contention of the defendant. Lords, my submission is that
Let's complete reading it.
on the perusal of the evidence of the above witness shows that the counsel for the defendant has already cross-examined in length to the above mentioned witness for more than 6 occasions. In the applications, counsel for the defendant has not mentioned any reason why this witness has to be recalled and what are the questions which are left during the cross. In the applications, it is stated that the plaintiff has suppressing the gifts and gold given by her father and brother and further denying developmental assistance in developing her husband's properties and filed the suit 4.5 years later, stating that she was not invited to partition and she was no knowledge about exhibit P4. Further, she has not received any amount, services, gift or huge quantity of gold from her father family, and she has not supported her contentions through evidence has to receive huge sum and financial assistance given to develop her husband's properties. These facts are already put in cross-examination and PW1 and same were denied by PW1 plaintiff during her cross-examination. Hence, once cross-examination of PW1 already completed, once again recalling of the above said witness or another witness does not survive any intention of the defendant counsel. The counsel for the defendant take maximum time for cross-examination PW1 and now the case is posted for argument. Hence, question of recalling the witness does not arise at all. Hence, the defendant has not made out any grounds for recalling PW1 with the reasons. I answer point number 1 in the negative. Because this application was not filed at the stage of arguments. Because this application was filed when my stage for evidence was still pending. Because it was filed way back in 2023. In the meanwhile, what had happened is I had filed one more application to bring additional witnesses on the defendant side. That application came to be rejected. I had challenged before this honorable court. The coordinate bench allowed that.
What is the stage of the suit now?
Now this state it is for arguments, my lords.
It is for arguments right from 2023.
No, my lords. After the
Let's
coordinate.
see your application. When did you file it?
My applications are at page 105. 27/11/2023. The objections was filed to these two IAs on 16/12/2023, which is at page 111, 110.
Take out notice. Please come. The office objections are overruled. The petition is permitted to take out hand summons on the counsel appearing with respondent before the trial court and file a memo to that effect. When can you file the memo?
The matter, my lords, it's been listed day to day. The only difficult, my lords, I'll just take 1 minute, my lords, I'll explain. The coordinate bench had disposed of the matter with a direction to dispose of the matter within 6 months. My lords, still 3 months is left. This stage is at arguments. My lords, I can
have it even on 11th also, but I'll not grant stay.
My lords, if I may request, the suit need not to be stayed, my lords, but at least pronouncement of judgment may be deferred, my lords. If not by 11th, they'll.
Why should we do it when I'm taking up the matter next week? Why should we do it?
My lords, the matter is being listed day to day. Tomorrow is the matter. If arguments are taken as heard, I will not be given an opportunity for an adjournment also.
I can take up on 10th also, but I'll not stay the suit. Yes.
My lords,
This is a matter on 10th. If the memo is filed by 9th, petition is permitted to take out hand summons. Yes, on the council affairs with respondent. Yes, next.
15. Where are DS?
For the petitioner, only office objection is that the execution petition is not, my lords, annexed to the petition. My lords, I am a judgment debtor. 10th of April, the petition is filed. 14th April, they, my lords, the Honorable Executing Court issues a show cause notice to the judgment debtor. That is the petitioner. Thereafter, my lords, on 15th April, the decree holder files an advancement application, obtains an order of delivery warrant, straight away barges into my property.
Whatever it is, why you can't file this application?
That's the reason, my lords, I had not even issued the notice. I'm awaiting the notice. Subsequently, only on 2nd June, I came to know about the execution proceedings. Certified copy has applied.
You can apply, when you can have the certified copy of the order.
Correct, I've applied.
Why can't you have the?
No, I have not produced the certified copy. It is an online case status. Nevertheless, I have produced the judgment and decree of the Honorable Trial Court on which the execution proceedings are filed. Also, I filed an application for dispensation insofar as the only office objection is concerned. Now, my lords, the difficulty is kindly see the impugned order at annexure A1 at page number 23. Page number 23, your lordships may kindly see.
What is impugned order 23?
Please, my lord, I'll come to that. My lords, the notice is issued on 15th April. Kindly come to page number 22. That is annexure A, previous page. This is the impugned order. Subsequent to issuing show cause notice, not even, my lords, having receipt of the show cause notice to the judgment debtor, advancement of the application is allowed, straight away delivery warrant is issued. Kindly see the photographs I have annexed at page number 26 for a minute.
This was decreed on 3/1/2026.
Sorry, my lords.
The suit was decreed on 3/1/2026.
Correct. Suit was decreed.
What is, why a notice is required to you?
No, suit was decreed. I'm only saying this suit, my lords, even I have obtained an order of permanent injunction as against the very decree holder. He's not challenged it.
No.
He's not challenged that order.
Execution proceedings.
Correct.
When the judgment was passed on 3/1/2026.
Correct.
A notice to you is required.
A notice is issued, nevertheless, rightly or wrongly.
Issued.
Issued.
Is it required?
Notice is required. I'm only saying this as per order 21 rule 23. If at all the judgment debtor does not opposes the application, thereafter order 21 rule 22 comes into play. Your lordships may kindly see the provision of order 21 rule 23 for a minute. And before going to that, kindly see the annexure D, page number 66. No breaking open of the lock is ordered. No police protection is ordered. There is a procedure. He has to, I'm saying this, let a delivery warrant be issued. I got an opportunity. I have to be heard before the delivery warrant is to be executed. I've got an opportunity to file objections to the delivery warrant. Straight away, my lords, coming and prior to issuing the show cause notice, delivery warrant could not have been issued. That is what the, my lords, even the provision says. Kindly for a minute, kindly see annexure D. I'm a senior citizen. I'm 79 years old. There is no police protection also ordered. I don't understand why the police officials are coming to my house. Kindly see annexure D series for a minute. My things are thrown out. And this order is subsequent to issuing show cause notice. Kindly see annexure D2 series. She is a lady. She is a petitioner.
Where is the judgment and decree?
Sorry, my lords.
Where is the judgment and decree?
Judgment and decree, your lordships may kindly see page number 45. This is the judgment he has obtained. It is an ex parte judgment. 45 is the judgment on which the present execution proceedings are initiated. The operative portion, your lordships may get it at page number 62, the decree. It is only for possession. For recovery of possession of Schedule B property, directing the defendant, henchman, agents, or whomsoever claiming under or through her to vacate and hand over vacant possession to the plaintiff and put the plaintiff in actual possession of the same, free from all encumbrances, liens, mortgage, court decree, and attachment, minor, major claims, or any kind of whatsoever.
Directed to vacate and hand over the vacant portion of the property to the plaintiff within 3 months from the date of this order. When did you come to know about this?
My lords, I have come to know of this order, my lords, 2 months back. I have preferred our appeal, regular. Sorry, my lords.
What happened to that?
That is still pending. Malas, we have moved the memo for posting also yesterday. When we are complied the office objections yesterday itself. It is bound to come, Malas, tomorrow or day after or Monday.
In that case, you have to seek stay of the execution proceedings.
No, execution proceedings, procedure has to be followed. Order 21, my lords, when a show cause notice is issued, my lords, the Honorable Executing Court does not wait and,
Contested the suit.
please, my lords.
Or you have not contested?
No, my lords, unfortunately, it is not contested. I have taken such a ground. I've taken such a ground. If your lordship sees once again the photographs at page number 70, annexure D8 and D9, is come with 50 people to throw out a old woman. I'm saying, let me be afforded an opportunity of hearing. I know I'm saying, I'm not on mercy. I'm not on mercy. I'm saying my submissions.
What I don't want.
Correct. I know. I have to bring it to your lordship's notice. It is high-handedness, complete high-handedness. I'm saying, let me be heard. Let me be there, an opportunity of being heard to me. Kindly see page 71. Your lordships may also see there is no police protection ordered and the police is there. Order 21, Rule 35,
Where do you see the police?
D7, 69, page 69. Order 21, Rule 35 specifically stipulates when there is specific objection by not handing over the possession or any of such kind by the judgment debtor, the Honorable Executing Court on an application being made as per proviso to section 3, subsection 3 of Order 21, Rule 35, court has got powers to order with the help of police head. No such application, straight away barging into my property, damaging my property. The main door is broken. No order is passed insofar as that is concerned. Even insofar as that, there is a procedure where an application has to be maintained. All this is done in a span of 10 days.
Notice to the respondent. And even the respondent is 87 years old.
Correct, my lords.
Petitioner is 79 years
correct, but he is, my lords, high-handedness I'm saying.
old.
I know.
No, so you're only pressing upon the senior.
No, I'm not only pressing.
Respondent is also a senior
Correct,
citizen.
correct.
And you conveniently don't appear before the court, don't take any notice.
No, execution proceedings.
So it's all technicalities, I understand that. Notice to the respondent. There shall be stay of all further proceedings. It is submitted that without any order, and the executing court has failed to follow the procedure after issuing notice to the respondent. Thereafter, warrant is issued, and the police, without following and without there being an order of police protection, police have come to the property and they have, without an order, they have break open the front door, submitted that the petitioner has already filed a miscellaneous seeking to set aside the ex parte judgment and decree.
RFM.
There shall be stay of all further proceedings. Pursuant to the order impugned dated so and so, petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 16th of June, list this matter on 17th. If the memo is not filed by 16th, the stay granted by this court stands vacated.
Your lordship's permission, may I request for hand delivery? I'm so grateful.
16, Santosha Nagarale.
Office objection shall be complied by the next date of hearing.
16,
Please. Ashif, this is a writ petition by the first defendant, my lord, in a suit for partition, my lord. When the matter posted for the further evidence of defendant, my lord, the first defendant filed application for amendment in the written statement under Order 6, Rule 17 with regard to the non-inclusion of the other properties of the propositors and the non-making of the other parties in the suit, my lord. But the trial court has rejected the application, my lord, by way of impugned order, my lord, which is at page number 43, my lord. My lord, before going to that, my lord, the proposed amendment which I have sought is at page number 27, my lord. It will go to the root of the case, my lord, because it is a suit for partition, my lord.
No. All this rejection of the plaints are numbered as, it's filed under 115.
My lord.
115. It's numbered as CRPs, all.
No, my lord. Writ petition GMCP, sir.
It's what was the discussion the other day. There are so many CRPs filed before the court. All rejection of the plaint.
No, my lord, this is rejection of my amendment application, my lord. This is
Amendment.
amendment. Return statement amendment, which is at page number 27, my lord. The proposed amendment is at page number 27.
What is the suit for?
Suit for partition, my lord.
In which year it is filed?
My lord, it is filed in the 22, my lord. OS number 116 of 22, my lord.
You are?
I am the first defendant, my lord,
Hmm.
in the suit, my lord.
IA is filed?
IA is filed under Order 6, Rule 17 for amendment of the return statement, my
When?
lord. My lord, it was filed on 2025, my lord. Issues were framed in the year
Look at your,
2023.
let's look at your IA.
My lord.
Let's look at your IA.
My lord, page number 27 schedule, my lord. The proposed amendment is, it is further submitted that originally suit scheduled property was belonged to one Puttarangama. Apart from suit scheduled property, said Puttarangama also owned other properties. All the properties of Puttarangama are not included in the present suit. Puttarangama died intestate, leaving behind her two sons, namely Srinivasappa and Chandrasekhappa, as well as three daughters, namely Kamalamma, Sundaramma, and Papamma, as her legal heirs. After the death of Puttarangama, all the sons and daughters were succeeded. The entire estate of deceased Puttarangama and having equal share in all the properties of Puttarangama. Even after the death of Puttarangama, there is no partition took place.
When that lady died, nothing, you don't say anything. Why you want to file this at this stage?
My lord,
Whether
because
these facts were in your knowledge earlier or not.
my lord, only the progeny of that one son by name
So why you cannot say these facts at the time of filing of the written statement?
My lord, by oversight it was
Don't even say
only
anything in your affidavit.
my lord,
Let's see.
due to slip of tongue, I have not instructed the fact involved in the proposed amendment, and due to old age,
What
it
is
was
the slip of tongue?
it was not memorized at the time of preparing my written statement. My lord, suppose if
Those are not the reasons on.
my lord, suppose
how
if the suit, if the defendant becomes unsuccessful, my lord, he will take this as a contention in the appeal, my lord.
That now what is the stage? It's
Evidence stage, my lord. Further evidence of the defendant, my lord. Suppose if he becomes unsuccessful, my lord, he may take this as a ground in the appeal, my lord. Sometimes court may also remand on that ground also, my lord. To avoid that
not on
such
these
things, my
grounds,
lord,
we can't allow the amendment of pleadings. Please come. The defendant in the suit is before this court, questioning the order passed on I number 6, filed under section order 6, rule 17 CPC, dated 6/4. It is, what is the date of the order?
my lord, the date of the order is 34/26.
34/20/26.
Impugned order is 34/26.
The suit is filed by the respondent herein, seeking partition of the suit scheduled properties. The petitioner is defendant number 1.
Please, ma'am.
This petition is the defendant number 1 in the suit. When the matter is posted for further evidence of
Defendant.
defendant, the present application came to be filed under order 6 rule 17, seeking amendment of the pleadings. By way of this amendment, the petitioner wants to insert the pleading stating that the property, originally the property belongs to one Puttarangama. Apart from the Sue scheduled properties, she owned other properties. All the properties were not included in the present suit. And she died, leaving behind her two sons.
3 daughters and also 3 daughters.
Huh?
2 sons and 3 daughters.
Are 2 sons and 3 daughters. It is the case that neither the entire properties nor the, the children of Puttarangama were impleaded in the suit. As such, the suit has to be dismissed for non-joinder of proper and necessary parties. And in the affidavit, it is stated that due to slip of tongue, the defendant has not instructed the facts involved in the proposed amendment. And due to old age, it was not memorized at the time of preparing the written statement. Hence, these facts have to be included. The court, the trial court, by order review, had dismissed the said application. While dismissing the application, the court has observed that in the case on hand, already the issues are framed by the court way back on 22/6/2023. And the present application is filed on 11/12/2025 when the suit was posted to further defendant's evidence. It is settled principle of law that once the issues are settled, the trial in the suit commences. In the circumstances, unless the defendant established due diligence on their part, why the proposed amendment could not be sought earlier, the application cannot be allowed. Moreover, the defendants have not produced any documents pertaining to the intending other properties and the legal heirs of the deceased Puttarangama to show that the said properties and the legal heirs. And by way of the proposed amendment, the defendants are trying to introduce a new fact and a new case which was not pleaded or disclosed earlier. And hence, the court has come to the conclusion that the amendment cannot be allowed. When counsel appearing for the petitioner defendant submits that it's a suit for partition and without impleading the necessary parties and the proper and necessary parties and also without including all the properties, such a suit cannot be filed. And this amendment is very much necessary to decide the dispute between the parties. Merely on the ground that it is filed at a belated stage cannot be a ground for the court to dismiss the application. It is submitted that in the interest of justice, the application has to be allowed. Expert, having heard the counsels on either side, that is the material on record. The suit is filed in the year 2022 and the issues are framed in the year 2023. Now in the year 2025, the application is filed under Order 6/270, seeking amendment of the pleadings. This court has perused the IA that is filed, the amendment that is sought, and the affidavit that is filed in support of the application seeking amendment, except stating the facts that the Puttama's children are not impleaded in the suit, and the other properties of Puttama are not included in the suit, except that, as rightly pointed out by the court, no other particulars are stated. And further, it is not the case of the petitioner that all these facts are not in the notice of the petitioner as on the date the written statement is filed, stating that as on the day she couldn't remember those facts and she couldn't instruct the counsel to incorporate these things in the written statement. It's not the ground on which the amendment of the pleadings can be permitted. The trial court, considering all these aspects, has rightly dismissed the petition, and this court finds no reason to interfere accordingly. Dismissed.
Please.
Yes.
Cell number 11, 17, cell number 17, B. Keshavamurthy.
I appear for the petitioner, madam.
Yes.
Annexure A, page number 10 is the impugned order, madam.
What is the suit for?
Suit for partition, my lord.
Hmm.
Suit for partition, the plaintiff, who is the sister of the supplicant, she, during the pendency of the suit, she bequeathed the property in favor of her brother. Subsequently, she passed away. Therefore, the plaintiff, the supplicant has filed an application to permit to continue the suit. Permit me to continue the suit. The application came to dismiss with the trial court.
Yes.
That is under challenge.
You are the brother of the plaintiff and you want to pursue the suit for partition,
Yes, ma'am.
which
During
is
the
filed by
life,
her seeking partition of the property of her.
father-in-laws,
Hmm.
her father-in-laws.
Yes,
She bequeathed the property during her lifetime in favor of her brother.
in favor of you.
Yes, ma'am.
You file an independent suit.
The suit is, in fact, he was the power of attorney holder for her sister. He was continuing the suit. The provision permit the, my lord, Order 22 Rule 10 empowers to continue the suit, my lord.
Hmm. The documents in respect to the suit scheduled property are produced by the plaintiff at the time of suit first stands in the name of father-in-law. And then the property stands in the name of Timmaya. On reflection of the names of the father-in-law of the plaintiff and other persons in revenue records, it appears that the property stands in the name of the family members of the plaintiff's husband and others. She filed the present suit for the relief of declaration and permanent injunction. If she has executed a GPA when she is no more, what is?
No, during her lifetime, she has executed power of attorney in favor of her brother to pursue, continue the suit.
That will not.
Subsequently, she executed a will, register will in
Will
favor
is
of.
a different aspect. As far as the GPA is concerned,
GPA
once
is
she
not,
no
now
more,
once she is dead, that will not survive. In view of the register will, the suit should continue.
notice to the respondent, petition permitted take for handsome and from the council a query for the respondent. File a memo to that effect. Is this matter in the month of July? Yes.
Cell number 18. For admission matter 018, Vignesh A.
Also back to appear for the petitioner. The petitioner is before this honorable court challenging an order rejecting an application order 7 rule 11. That's brief facts are germane, my lords, before I get in the application itself. The land was granted to the propositess, one Pujama, in 1979. Thereafter, she alienates.
What's the suit for?
It's a suit for partition, my lords.
Suit for partition.
Please.
On what ground you have filed the application for
Lords,
rejection?
on the legal impossibility that the successors of a female predecessor constitute a Hindu undivided family with the predecessor's male contemporaries. Essentially, Pujama had 3 legal heirs, 2 sons and 1 daughter, Venkata Lakshmama. The plaintiffs before the trial court are the wife of the predeceased son of Pujama and his children, essentially the grandchildren of the female successor of the propositess and her daughter-in-law. They have filed a suit for partition against their mother-in-law and grandmother's brothers, claiming that they constitute a HUF with them. And it's a co-parsonage property, which, my lords, is also a word in the Order 7 Rule 11 application, is a legal impossibility and settled principle of law from various decisions rendered by the Honorable Apex Court to our Honorable High Court as well, my lords. And the second ground in which the suit on the Order 7 Rule 11 application was filed was in respect of alienation having occurred in the year 2014 itself.
You are the purchaser.
I'm the purchaser. I am the purchaser from defendants number 1 to 13, who are the children of the male legal heirs and the one son of the propositors. My lords, the question is simply this: how it's a legal impossibility that the children of a female heir constitute a joint family with the male counterparts. That's number one. Number two, in 2014 itself, there was an agreement of sale effected, signed by Venkata Lakshmama, who's alleged predecessor in title of these plaintiffs. They conveniently suppressed this, my lords. If my lords may come to para 9, my lords, of the plaintiff, they have suppressed this. They say this agreement of sale was executed without their consent.
Suppression of fact is also a ground to
Please,
reject the plaintiff.
please, para 9 is a blatant suppression. They say that the agreement of sale dated 28/1/2014 was executed without their consent, but they conveniently leave out the fact that their alleged predecessor in title, Srimati Venkata Lakshmama, was a party. She was paid money, and they also conveniently suppressed the GPA for consideration, my lords. There's a landmark judgment of this Honorable High Court, my lords. When a GPA for consideration is executed contemporaneously with a agreement of sale, an agency does not die with the donie's death itself. And basis this,
Those are all on the merits of the matter. How do you expect the court to decide all this?
No, my
on
lords.
an,
No, my
Order
lords.
7, Rule 11?
my lords, because it's the legal impossibility. If my lords, we just come to para 9 of the plaint. It's a legal impossibility, my lords. It's a legal impossibility and it's on the ex facie in the plaint itself.
Where is the document for the court to see? To the
Please.
trial court while deciding this application?
Please, please.
What are the documents that are filed along with the plaint?
Agreement of sale and the sale deed. If my lords, we just come to para 9 of the plaint.
Before
my
that, we
lords.
will see the order of the court.
Please. Is that 38 to 50, my lords? And next to A. Various.
Come to para 8.
Please. Para 8 of the order, my lords. So the trial court records that these grounds were raised, but doesn't necessarily address them. There is no adjudication on this question of whether it's possible for the descendants to have constituted.
Let's read.
Please.
Read para 10.
Para 10. May I read aloud, my lords? In view of the settled position of law, only the plaint averments to be looked into while deciding an application to Order 7, Rule 11. No. On careful reading of the entire plaint averments, it's forthcoming that the plaintiffs have specifically pleaded the suit property is initially granted the name Puja Ma for the benefit of the joint family. It was sold by her in favor of the father of defendant number 14, which was set aside by the AC, and the property is restored in favor of LRs of Pujama. It is the case of the plaintiffs that the subsequent documents created by defense number 1 to 13 in favor of defendant number 15 and 16 are not binding on them. It is also claimed by the plaintiffs that the suit property is available for partition, and the plaintiffs are entitled to a specific share in the same. The cause of action is shown to have arose on 10/10/2024 when the plaintiffs demanded for partition of the suit property. It is also clearly stated that the registered sale deed dated 16/7/2021, standing in favor of defendant number 15 and 16, also JDA dated 22/10/2021, executed by defense number 15 and 16 in favor of defendant number 17. It shows that there is no suppression of material facts by the plaintiffs in the plaint. Insofar as the cause of action is concerned, the same is a bundle of facts and should be gathered by reading the entire plaint averments. At this initial stage, it cannot be held that there is no cause of action to file the suit. My lords, in respect to the suppression, my lords, if my lady may come to para 9 of the plaint.
Notice to the respondent. Petition is permitted to take out.
May stay of proceedings be granted, my lords.
Petition is permitted to take out handsomely.
Lords, I'm filing a memo for dispensation of notice to
30th of June.
My
The
lady.
memo is filed. This is a matter on 1st of July.
My lady, I'm filing a memo for dispensation notice to R5 to R20.
Memo is filed seeking dispensation.
They're
notice to
non-contesting parties. R5 to R20, my lords. My
R5 to
co-defendants.
R20.
Please.
R5 to R20, dispense with the risk of appellant. Notice to R1 to R4, the same councils of the. Yes.
Cell number 19.
Please.
For the petitioner, my lords.
Yeah.
My lord, the respondent filed the suit for permanent injunction against the petitioner, my lords. The petitioner filed an application in IA number 2 under Order 7, Rule 11D of CPC for rejecting the plaint on the grounds of civil suit is barred against the petitioner, my lords, on the ground that under Section 118C of Karnataka Cooperative Societies Act.
District Cooperative Central Bank. Come to the plaint. What is the dispute? Let's see. Where is your written statement?
Annexure E, my lords, page number 44 to 48, my lords.
It is with regard to the declaration of title to the property. How can you decide that? How can the cooperative society decide that? According to the cooperative society, somebody has mortgaged the property and she has purchased the property way back in the year 2003. How can it be, how this will fall within section 70 of the act?
My lords, it is the same property that they have.
No,
been-
you only say, if you look at your plain, the written statement, it says the scheduled property corresponds to the sue scheduled property. And some Nagaraja has mortgaged the property and she has not purchased the property from Nagaraja. She purchased the property one from Shobha, which is in the year 2003. In the written statement, you don't even say anything. When was the property is mortgaged? Nothing. How can the written statement be so vague? Please come to the order now. Khata has been created over the suit scheduled property in the year 2008, whereas the plaintiff has purchased the property in the year 2003. Correct. The order is correct.
My lords.
Order is correct. Because it doesn't touch upon the business of the cooperative society.
Kindly please look into page number 22, my lords.
Page
Para
number?
16, 22, my lords, of the order. Para 16, my lords.
22. Yes, I've seen that. 118 I have seen, 70 I have seen. But the dispute is not such. Shall I dismiss or your senior will come?
Pass over, my lords.
Pass over.
Number 20. Kumar.
In challenging the order passed on IA number 1, in OS number 157/2025, which is at annexure of page 38 motion. Rejection of client came to be
What is
rejected.
this for?
Suit for partition separate possession and the special suitable properties filed by the
IA is filed on what ground?
on ground note, the prior to filing the present suit, the earlier suit was filed in respect of the same properties for same relief, one of the other defendants. Who are in the defendants, they filed the
According
suit.
to you, it's barred by res judicata.
Yes, ma'am. Bar will not, or it's bar under the 30 or 23 rule 3A to bar to file a fresh suit. Where there is a compromise petition is recorded, compromise decree has been drawn. He was the party in that earlier proceedings. They cannot file the fresh suit for setting the compromise decree.
That you have filed along with your written statement.
Yes, my lord.
How can the court consider that?
That's what, madam, before this lordship, not kindly peruse the interim order, my lord.
Considering
My
an
application
IA
may kindly be seen, my lord.
While considering IA under order 7 to 11, except the plaint and the documents that are filed along with the plaint, the court will not look into any other document. What you have filed along with your written statement or the documents, court cannot look into.
No, because I placed the compromise decree. You will may kindly appreciate that. Yes.
Before appreciating that, you have to answer to my question.
Please, madam. Please, madam.
Can the court look into
Please.
whether the court can look into the
No,
written
no, court has
statement?
not at all considered order 23 rule 3A. See, what my respectful submission before this note, in the earlier suit, compromise petition came to be filed. In that suit, the present plaintiff is one of the party in that proceedings. She is well aware of that.
Yes. All these facts you have stated by way of a written statement.
And as well as the
But not-
application in the order of 7 to 11.
Yes.
Yes.
While considering your application, will the court look at the written statement? Can it look into?
Yes, my lord.
Yes, please come.
Yes.
The present writ petition is filed. Agreed with the order.
Page 44.
I am also confirming, I'll impose another, the cost of another 5,000. What the court has imposed 100, I'll impose for another 5,000.
For the reason, my lord, because Order 23 rule 3
You
is
are not
not.
understanding you have to argue on legally, on basing on law.
Please,
You
ma'am.
say that I filed a different written statement, court has to look at the written statement while rejecting the plaint.
No, my lord, first I filed the application order 7 rule 11 to reject the plaint as there is no cause of action. Earlier suit has been already decided, compromise decree has been drawn. In that proceedings, the present plaintiff was part in that proceedings. Hence, order 23 will raise a bar. That was the contention in the rejection of plaint. Without considering order 23 rule 3A, application came to be rejected. You may kindly para 11 of the impugned order may kindly be seen, my lord. Without giving any findings, order 23 rule 3A. May I read, my lordship? The applicant in her application has simply praised to reject the plaint as there is no cause of action for the above suit and also barred by law. But the applicant has not made out ground to how the suit is not maintainable and on what provisions of law present suit is barred. The application also not made out ground to show that there is no cause of action for the suit. Accordingly, the applicant is not made out the grounds to allow the application. On the only this ground, the application came to be rejected. What my respectful submission, what my grievance is that already suit was filed in respect of the same properties. The present plaintiff is arrived as one of the defendant. He has filed the wakalat. She is well aware of the earlier proceedings. Her ground only she is having a right to sue the suit. She can file the application before the same court for setting the comparable decree. That's what I'm relaying the Supreme Court order. Kindly.
Before going to the Supreme Court judgment, come to your IA.
Please. Para 4 of the IA, kindly be seen note. I further submit that suit property are the ancestral property of the plaintiff and defendant. The suit of property already partitioned by filing a compromise petition in OS number 188/23, wherein the first plaintiff also arrived as a defendant number 1. She filed wakalat in the above case. Therefore, she well aware of the proceedings and her share was reserved. The suit of properties are divided into 4 parts as there are 2 plaintiffs and 2 defendants. The defendant 1 and 2 have released their share in for the defendant number 3 by receiving rupees 5 lakhs each. Therefore, the plaintiff have no right to file a present suit for claiming the same relief. I further submit that the application and order 23.
No, what is the relief in the suit? Suit is for partition.
Yes, ma'am.
Where is he seeking to set aside the earlier compromise decree?
No, my lord, CF filed the fresh suit for seeking the same relief of partition in separate possession. In earlier suit, she is one of the defendant. The other defendant files a suit for partition in respect of the very same properties, which came to be compromised. Compromise decree has been drawn. If they are not satisfied, she has to file an application before the same court for setting aside the compromise, not filing the fresh suit. That's what I'm requesting this court's order 23 rule says bar to file a fresh suit.
We are not on that point.
Please, ma'am.
So what is stated in the plaint and what are the documents filed along with the plaint and whether whatever is the stand that
Yes,
you are taking,
you know,
is it available for the court? That is what I'm asking from the beginning.
Yes, in the plaint, my lord, she has stated that the other defendants colluded with each other. They got the partition. They have filed the partition and they taken their share. This is only their contention in the present plight. In earlier suit, she was one of the defendants. She filed wakalat. By suppressing on the facts, she has filed the present suit for partition separate possession. Her share was reserved in the earlier suit in the compromise decree.
Notice to the respondent.
No, kindly interim order, ma'am.
I'm not able to
So,
understand.
my lord,
the
this
case,
is
let
suit
understand.
for the leading the evidence, my lord.
Let it be.
So, there is a specific provision, my lord.
Notice to the respondents. Petition is permitted to take out handsomens and shall file a memo to that effect by 30th of, if the memo is filed, is the matter on first.
Yes. Number 21. 21.
In this matter,
Can
Milords,
Vishwanatha?
the name of the petitioner has been wrongly mentioned, Milords. I may be permitted to file necessary
What is
application for correction. Name of the petitioner, Milords, has been wrongly mentioned. Milords, some correction amendment is necessary, Milords. I may be
Mysore
permitted.
City Housing Cooperative Society Limited.
Please, Milords, it should have been Mysore City cooperative housing society. The words have been interchanged.
Yes. You want an adjournment?
Please, Millards, I'll find necessary
Petitioner?
application.
It is submitted that the name of the petitioner is, there is a typographical mistake in mentioning the name of the petition, they may be, and the petitioner may be permitted to correct the same. Yes, petitioner can carry out the necessary corrections. Give it to her. Yes, next.
Then number 22.
This
Akash
is
Kumar
matter
Soda.
next week. Yes.
Petitions Council. The defense application for rejecting the plaintiff has been rejected. But the agreement is dated 1/10/2015.
Suit is for specific performance.
Yes, madam. Suit for specific performance. The time agreed is 6 months from the date of the agreement. The suit filed on 27/4/2024. It is filed after 5 years, after the lapse of 5 years. It should have been filed from 1/6/2016.
No. The plaintiff must have stated what is the cause of action.
True, my
Whether
lord.
he is entitled for a relief contrary to the agreement of sale is what will be decided in the.
Kindly say, my lord. Here, my lord, the judgment of the Honorable Supreme Court, my lord, under Article 54, the time stipulated is agreed time. The first part of the Article 54 is, if the time is stipulated, then here, my lord, admittedly, the time stipulated is 6 months. Then, my lord, the limitation starts from the expiry of the 6 months.
No, that is
So
one
there-
aspect there. Let us please come to the plaintiff. What did they say? What is the cause of action?
The cause of action, my lord, they say, the first, sorry, my lord, my oversight, the last page has not been produced of the plaint. Sorry.
The defendant is not showing any interest in executing the sale deed in favor of the plaintiff by receiving a balance sale consideration amount. The cause of action for the suit arose on 1/10/2015, 25/11/2022, 27/2/2023, and when the reply notice was caused by the plaintiff, and on 15/8/2024.
My lord, I have not brought some of the judgment. There is judgment of the Honorable Court as well as the Supreme Court. If, my lord, Article 54, my lord, then it is liable to be rejected. Tomorrow, my lord, I will produce those documents.
No, that law cannot be applied at the time of this, at the time of.
No, on that point, my lord, there are judgment of the Honorable
Yes.
Court. I will.
No, for example.
Next matter.
No, as per that, after that, the plaintiff himself will say, the defendant says that I'm not able to execute the agreement, give me for some more time. Those kind of correspondence will go on between the plaintiff and the defendant. How will we apply the law of limitation then?
Tomorrow,
It all depends upon facts and circumstances of each case.
True, my lord, I will bring it.
Yes, tomorrow.
Next matter also same.
Tomorrow not possible, list it on Monday.
Next matter also same.
Yes.
Serial number 24. 24.
Final order by the small causes court challenge before your lordship. Suit for recovery of money.
Recovery of?
Money.
Hmm.
1,15,000 rupees was the claim.
What happened?
Not the suit comes to be decreed in favor of the plaintiff, the defendant before your lordships. The only ground I'm on, my lord, is that I was not given an opportunity to cross-examine or lead my evidence at all.
What is the amount?
The amount is 1,13,897.
897. How much you're going to pay?
I'll deposit not whatever your lordship suggests for the moment.
How much?
20%, my lord, your lordship. 20%.
No, it should be 50%.
And
Please come. But it is agreed with the order passed by the small causes court, whereby the suit filed by the plaintiff is decreed for an amount of rupees 1,73,897. The.
Not 1,13,000.
Sorry, 1,13,897. When counsel for the petitioner, defendant submits that the court has not given a proper opportunity to the petitioner to adduce the evidence and to cross-examine the plaintiff. Considering the same, there shall be stay of all further proceeding pursuant to the judgment and decree on the condition that the petitioner shall deposit an amount of rupees 55,000 within a period of 4 weeks from the date of receipt of the copy of the order. issue emergent notice to respond.
Obliged, please.
So number 25, Ramesh Chandra.
For the petitioner.
For the respondent, Your Lordship.
This is the defendant's writ petition, the revision petition. A small cause suit was filed seeking possession and also injunction. I filed written statement along with the order 7 rule 11 saying that injunction suit is not maintainable in a small causes suit. The court says it is maintainable. That's why your lordship kindly say section 8 of the small cause court act.
Yes.
Shall I pass on me? 8 and schedule. Section 8 indicates what are all the suits maintainable. Exceptions are carved. It is scheduled. Last injunction suit is exception. I have marked 16.
These are all the exceptions.
Yes, ma'am. 16, injunction suit is an exception.
Suits exempted from the cognizance of the court of small causes.
Yes, ma'am.
Suit to obtain injunction.
Yes, ma'am.
Lord, suit is one for eviction, Your Lords, and they've been using the property as well. And
You say it's a suit for.
no, we've not been served the copy yet, Your Lords.
Notice is not.
Notice,
ordered.
notice not yet issued, Your Lords.
Notice
Please,
that
please.
issued, He
So it's
came,
a
he has not filed any
suit to
caveat.
obtain an injunction.
Please, Your Lords, please.
Yes. Let's see, where is the plaint?
Plaint I have filed. You lost my kindly see plaint. Plaint at page number 28. Last class C.
When you realize this, when the matter is for cross of PW1?
No. What happened immediately after filing return statement? I have this one. Cross of PW, it is not there.
Under order, no, they say.
Along with the statement.
The defendant has filed this application when the suit was posted for cross of PW1.
Yes.
That's what the court says at point number
Maybe.
7.
Because I have taken up a contention.
The
In a
suit
written
is
statement,
for
I have taken up a.
Eviction.
You lost my kindly see the last
Eviction
class
against
C.
the defendant in respect of the suit scheduled property.
Yes, ma'am.
An order of arrears of rent and an order of permanent injunction.
Yes.
Restraining the defendants from transferring the suit.
Permanent order.
So only C is not maintainable.
C is not maintainable. So your lost maker, it cannot be bifurcated now. Because when a suit for injunction is filed, it is the civil code. Your section 9 may kindly be seen, CPC.
Let's see the plaint again. There is a
That
plaint
is, the
number.
court says it is an auxiliary relief, whether a main relief or auxiliary relief.
We look at it.
Yes.
Where is it? The plaint.
It's 28.
28. Yes.
Because civil suit, the small causes court was jurisdiction of the small causes court up to 2 lakhs in civil court, the small causes court. Other than eviction, also ejectment also lies before this city civil court, section 9. That was decided by this honorable court in
According to you, only prayer B is available before the small causes. Court.
Yes, Lord. Your Lordship, this is the full bench decision which decided that how the small causes court gets its jurisdiction. Up to 2 lakhs, small cause court has jurisdiction. It is a full bench decision. Now, I don't say that small cause court is not maintained as a jurisdiction. When an injunction is sought, it is for the civil court only. Section 9.
Your Lords, let a date be fixed, Your Lords, and we shall make necessary submissions and objections.
Now the court is cases.
Submits that the small causes court has no jurisdiction to entertain a prayer seeking injunction. It draws the attention of the court to section 26, wherein it shows the exceptions to section 26, 20.
8, section 8.
He draws the attention of the court to section 8 and the schedule appended to that, whereby as per 16, a suit to obtain injunction is not maintainable before the small causes court. And the court, without considering this aspect, has dismissed the IA. Considering the same, there shall be stay of all further proceedings pursuant to the so-and-so in the next date of hearing.
One humble submission, Your Lords. The suit is for eviction. They're not paying the amount there as well. And the outstanding amount.
You can argue
Please,
the matter.
please. A date may kindly be
So-and-so submits that, write your name.
Please.
So-and-so submits that he has instructions to file wakalat.
Wakalat has been filed.
Wakalat has already been filed, Your Lords.
Oh, even
Without
before
notice
notice.
ಅಂತ ಮಾಡಿದ್ರು.
And please.
Stay and list this matter on 2nd of July.
Please, Your Lords.
ಮುಚ್ಚಾಡು.
And a copy may kindly be served.
Files are
A copy of the
Please,
he is not sick when he enters.
petition.
please.
List number 2, for preliminary hearing, cell number 1, Ashwath Narayan Reddy.
My lords, I appear for the respondent number 1, 2, 3, 5, 6, and 7.
Insofar as my lords, see, it is a public money where the officers who are all working under the MESCOM are hand in glove by looting the money of the state exchequer.
Please come to the prayer. What are you seeking?
Yes,
Then we will go to the other aspects.
Petitioner number,
What is the prayer you are seeking?
sought for direction, directing the,
Consider the
sought for madam
Complaint
of
dated
direction,
24/12/2025
complaint.
against respondent number 5. Who is respondent number 5?
Respondent number
I
5
appear
is
for
the
respondent
HS
number 5.
Malleshappa, Assistant Executive Engineer. Respondent number 5.
What did he do?
He is himself, he has written a MB book. According to MESCOM rules, the MB book has to be written by the measurement and project of the contract tender has to be by the junior engineer, not by the, he himself have obtained a tender order. He himself has nominated one of the,
So,
minute.
who are you?
I am the contractor number, class 1 contractor of the KPWD. I am also one of the contractors. They are without doing the drainage, without doing the road work. The respondent number 5 has mischieved the public money that to become our on the state exchequer.
If that is the case, file a public interest litigation. How are you affected?
No, that is not, where misappropriation is, we have made a complaint that has not been considered by the authorities.
Who are
They have
you?
not passed any order.
Not your personal grievance. You are saying that it's a toll on the state exchequer. Then it's a public interest litigation. Go before the first court.
See, one submission, my lord. I have, for which I have made a complaint to representation to the managing director of the MESCOM. They have not taken any action. I have filed a police complaint. They have not taken any action. All are hand in glove. What we can do? That is a proper fact before I have put forth before your lordships kindly. Where,
How are you affected, I'm asking?
yes, ma'am.
What is your personal grievance in this?
Personal grievances means without doing the.
You're doing something according to you in the interest of the society. Isn't it?
No, not that. They have, engineers are becoming contractors. What would be the contract faith in the society?
Please answer. Are you affected personally? I'm asking.
I am not personal attack because they, without doing the any contract work, I have produced the photographs to show that even the chamber plates have not been put on the plates. Plates have not been put on the chambers also. All these things I have produced the photographs. Your lordship kindly see Alex
Yes.
H. And your lordship kindly see the photographs.
My lords, all the contention that's raised, my lords, your lordship have clearly observed, my lords, it's a public interest. And And here, my lords, the petitioner has no personal grievance. And with respect to this, my lords, another aspect is that the petitioner had also filed a complaint before Upalokayukta, my lords, stating the same. And Upalokayukta has also dismissed the complaint of the petitioner,
You have a
stating that he
copy
is
of it?
not. I have the copy, my lords, but it's in Kannada, my lords. I have to get it translated. ಕೊಡ್ತೇನೆ, sir. However, my lords,
You are
this-
not aware of your complaint being dismissed.
Well,
You are not aware of your complaint being dismissed by Lokayukta.
no, I am not aware about that complaint was dismissed. I am not aware.
Copy. Tomorrow I'll dismiss this writ petition with cause. This is part tomorrow.
Copy.
ಕೊಡ್ತೇನೆ, sir.
Case number 2,
I'll place it, my lords.
Your Lordship kindly have it on Monday. I have to take instruction on
Yes, Monday, and tell your client I'm going to impose costs.
case number 2.
Monday minutes.
Monday.
Yes.
Lordships, in this case, I'm appearing for the petitioner. Lordships, I had filed an interim application before the trial court seeking cross-examination of defendant number 2 and defendant number 4 through defendant number 2 by video conferencing, my lordships. That application has been dismissed, my lordships, by virtue of which I'm.
Why you want video
My lordships,
conferencing?
he is 75 years old and he's suffering from medical conditions, my lordships. He's 75 years old and he's suffering from medical conditions, my lordships. I produced the
And
medical.
what about other witnesses? You said so. You've
Sorry,
given a
ma'am.
list of it. It's only one witness or?
Defendant number 2 and defendant number 4 through defendant number 2, my lordships. Defendant number 4 is a company for which defendant number 2 was the CEO, is the CEO. So only for defendant number 2 and 4, I have filed my application, my lordships.
Let's see that.
Sure, my lordships. The impugn order is at page number 27, my lordships.
What is the suit for?
The suit is filed by the respondent number 1, challenging his termination and for damages, my lordships. He was the employee of defendant number 4, my lordships.
Yes. Where is the order?
The impugn order is at page number 27, my lordships. My lordship, may I draw my lordship's attention to para number 440 at page number 44, my lordships.
Insofar as defendant number 1 is concerned,
We are not challenging that.
the grounds urged are primarily professional engagement and business inconvenience.
As far as defendant number 1 is concerned, I'm not challenging the order, my lordships. He's already before the court and,
With respect to defendant number 2.
yes, my lordships,
reliance
para
is
number
based
40,
upon
my lord.
age and spinal ailments. While this court is not unmindful of consideration of health and dignity, no categorical medical certificate prohibiting air travel has been. Where is the court?
So,
Where is the court situated? Which court is this?
this is before the trial court in Bangalore, my lordships.
And where is the?
He's in Delhi, my lordships.
The medical reports placed on record indicate chronic degenerative changes, but do not demonstrate acute incapacity or immobility.
My lordships, I have produced the medical records filed before the trial court.
The
by
plaintiff
means-
has specifically contended that defendant number 2 has undertaken international travel during the relevant period. This contention remains uncontroverted by cogent material. A 3-hour domestic flight to Bangalore cannot, in the absence of medical prohibition, be equated with impossibility.
My lordships, that's a misleading statement by the defendants, by the respondent number 1, my lordships.
So why have you denied that?
I produced the passport at page number 275, my lordships, which says that he has not undertaken travel in the recent past, for the last 3 years, my lordships. And also I have produced the medical certificate also, my lordships, at page number 295.
Further, Rule 6.2 of the High Court of Karnataka so mandates prior consultation with the opposite party before moving a request for video conference, except in urgent circumstances. No, how many documents are filed? 136 documents are marked by the
plaintiff. Yes, my lordships.
Why can't let you come, once you come, we'll ask them to complete it within 2-3 days.
My lordships, that's what we had requested for the defendant number 1 also, my lordships. But till date, I think 5 hearings have happened. And every hearing, he goes back and he comes again. So the matter is set for a hearing day after tomorrow, my lordships.
No.
And because of his advanced age, that's the reason why we're seeking, my lordships.
How much time you require to cross-examine?
Maximally within a day we will come. Within a day.
1 day is sufficient.
Last time also they have cross-examined in.
He's saying 1 day.
My lordships, for defendant number 1, they've already finished
Actually, they have said
five
that-
hearings.
So you're not on defendant number 1.
No, my lordships.
You're
So the
on
6th
defendant number
hearing
2.
was on, what I'm trying to say is the
Yeah,
conduct of the
defendant-
parties. my
Defendant
lordships.
number 2, how much time you require? For that day, you just come for 1 day and finish it off.
My lordships, he is in an advanced age, and because of his medical conditions, he can't travel, my
What's the
lordships.
medical condition?
My lordships, I produced the
They are,
certificates, my
giving the
lordships.
statements that only the spinal.
How is it possible?
Spinal injury.
Is the prime witness in this or not? On the,
He's a prime witness, my lordships, but what we are saying is, because of technology, the advantage can be taken. because
that's
of
true,
technology.
133 documents.
That's produced by the plaintiff, my lordships. I have produced only 5 documents, my lordships.
Because
That's
he
it.
is the plaintiff, he has to prove his case.
My lordships, it's an employment contract. He has been terminated as per the contract. He's only harassing the defendants and have made even the group companies of the defendants as
If it is
parties.
possible in a day, please come down and I will direct them to complete it in a day.
Lordships, I would request my lordships to kindly consider my writ petition because of his advance. I have produced the medical records also, my lordships. I would like to take my lordships through the medical records. I produced it by a memo on the last date of hearing on 22/4/2026.
Where is that?
I've also produced the medical certificate also, my lordships, by the doctors at page number 295. The 295 is the description, but I produced a type copy at 296, my lordships.
My lord, they have not submitted anything except the prescription. They have not submitted any X-ray or other documents relating to the major injuries. Just saying.
I have produced already, sir. I've given you a copy.
Yes, madam, you are saying that 295 is only the.
What we have produced with the trial court, we have given you on the last date of hearing.
Yes. Now you are saying just only the prescription is.
To read it, what is the doctor's I'm not able to, it's not clear.
The typed copy is on the next page, my lordships, the 296. Certified that Mr. Vijay Kumar Suri is under my follow-up. He is suffering from systematic hypertension with lumbar spondylitis and was operated for urethral stricture. Because of his low back ache and urinary incontinence, he has been advised to restrict his activities and also avoid long.
Cannot be, why you can't cross-examine him? The video conference, why can't you cross-examine him?
Through
By a
video
video
conference means it will be issues for us. It will be a damage for the case. Damage for the
Damage for the?
suit.
Huh?
Damage for the suit.
What did you say? Damage? Damage for the suit.
Video conference antandre anyone can help through that. They can be prepared early and they can like something it will be manageable. 130 etc. documents means they have to present and they have to say, they are saying simply that a spinal injury, it is not a major issue that in this they have not mentioned the date also. On which date? 26. We can get this. Many of the patients are coming and they are attending the courts.
When is it posted for the evidence of date?
My lordships is posted on 6th of June for the evidence of defendant number, for the cross-examination of defendant number 1, my lordships.
2, it will come later.
It will come late. After he complete.
At best what the court can do is, in one day, I'll ask them to complete it, nothing more than that.
My lordships, there are plethora of decisions by the Honorable Supreme Court, asking.
The decisions are either ways.
My lordships, no, my lordships. I would like to produce one particular president of the Honorable Supreme Court.
With your lordship's kind permission, my lords.
Yes.
I request your lordships, if your lordships are, hearing the matter at 2:30, my lord. I'm in the midst of another matter in Kalburgi bench, my lords.
You're appearing in which matter?
In the same matter, my lords, I'm for the plaintiff, respondent plaintiff.
Yes.
In the afternoon session, my lords.
Then number 3, Deepak Bhaskar. Kumar for respondent.
This is no representation, this is matter in the month of August. No interim order. No.
My senior is held up in the arbitration. Kindly pass it over to 2:30, your lordships. He'll address them.
Monday, my lord.
2:30, your lordships.
Monday, you're taking a chance. It will go to the third list. All adjourned matters will go to the third list. This list will continue.
Cross-examination, that's why I have a
Your
cross-examination.
ladyship, your ladyship, this is a matter. It's a probate matter.
She has some inconvenience. What we can do Monday?
Monday, could it kindly be taken in the first
Wherever
list?
it is, it will come. I can't ensure you that.
Your ladyship, because in this matter, we are challenging a probate in which the petitioner was not even made a necessary, she's a necessary party by virtue of being a class 1 heir. She was not even made party to it and it's been-
Monday, yes.
Cell number 4. T. Subramani for petitioner.
Ask you for the response, number 11.
I'm the petitioner in this case.
Yes.
My lord, suit is for partitions filed by the plaintiffs against dependents and purchaser, that is dependent number 3 is this case. My lordship, kindly see, I am for the impleading applicant in this case. File 1 rule 10 class 2 of CPC, impleading me as the necessary party.
That is dismissed. That is dismissed.
Yes, sir.
Where is that order? Please come to that.
My lordship, kindly look into the annexure G, family T of the petitioner and dependents, impleading applicant, page number 69. Family T of this. One Peddana is the Karta of the family.
There is no page number 69.
16, 70, 16, a typed copy and is the
67, yes.
yes. Peddana is the Karta of the family. He had 3 children, 5 children, Tippamma, Narayanappa, Balapreddy, Lakshmamma and Gauramma. I am the son of the Gauramma, the last daughter.
The plaintiffs are the children of the Narayanappa. That is, children, yes. He filed partition suit against,
And you were not impleaded.
yes.
Let's come
That
to
is-
the order now.
Yes.
Come to the order, impugned order.
Impugned order, for impleading applicant, plaintiffs have no objections. The purchaser objected and filed objection. Plaintiffs have no objection.
Where is the order? Come to the order. Where is the reasoning?
Order, page number 11, annexure A.
Come to page number 17, bottom, in view of the principles laid down in the above decision.
Yes, my lord. My lord. My lord, page number 16, page number 7. The dependent, the land council for the dependent number 3 has produced the copy of the order passed in WP number 29778 of 2017, wherein
The reasoning of the court.
My lords, there were, prior to this petition, this application, there was another round of same application filed by Balappa Reddy as the family tree may kindly be perused. And that, there is an order passed in that, and that was challenged before this honorable court in WP 29778 of 2017. Prior to this suit, there was another suit filed by the impleading applicants for partition, and that is numbered as OS 1168 of 2004. If at all any remedies are available for the impleading applicant, the same can be exercised in that suit, is what has been decided. I will draw
How many partition suits will be filed in between the very same family members?
it is filed between the family members, but this is a separate partition suit decided by the family
Seeking
members of
partition of which properties?
this is a separate subject matter, entirely not covered under.
Let's see the plaint.
Yes. This is a partition suit for 9.5 guntas of land.
Let's see, where is the plaint? Who are the plaintiffs in the suit?
The plaintiffs or the family tree may kindly be perused, which is, it is a suit between Narayanappa and the family members there. It is not a suit between other family members. The family tree talks about second Narayanappa. The suit is between Narayanappa and the sons with respect to a separate.
Above 4 or all, it says all son, daughter and sons of late Parvatamma. Who is Parvatamma?
Parvatamma is the daughter of Narayanappa.
Parvatamma, where is she? Parvati is daughter of
Narayanappa.
Narayanappa.
Yes.
Ah.
She filed.
What was the earlier comprehensive suit?
The suit was for partition, which is still subsisting, my lord.
What is that? What is
I
the,
will draw your lordship's attention to the
what is the
WP
number
orders.
of that suit?
The
OS
WP
number?
orders may kindly be perused.
No, what is the number of the suit?
The number of the suit is 1168 of
2004.
1168
of 2004.
1168. And I produced a copy of the judgment of the suit here. It is already dismissed.
Let us see where is that.
Yes, I've already produced before the full court. The judgment is produced on the last hearing date.
My lordship, that is different parties, different.
Let him submit.
And this is initiated by the impleading applicants.
First, let me look at what is that you have filed and where is it?
On the last previous hearing. OS 1168 2004 judgment.
OS number 1168.
So, and Timmappa.
Tippamma.
Tippamma
Who
is
is
the
Tippamma?
impleading applicant here.
No, impleading applicant is Venkatesh.
The Venkatesh
Is the impleading
is the
applicant.
legal heir of Tippamma and
Gauramma.
So the
What is the applicant's name?
Venkatesh is the son of Gauramma, the daughter of Peddanna,
Hmm.
and sister of Narayanappa.
So let's look at the cause title of this. Tippamma, that is one of the daughter of
Peddanna.
Peddanna.
Yes.
Then who are the other? Where are you? Where is he?
my lords, the family tree may kindly be perused.
I'm looking at the family tree.
Family tree, Tippamma's daughter, Amita Reddy.
Come to page 2 of this judgment which you have placed.
Yes, my lords. Tippamma is no more. Passed away. So the legal heirs have come on record, my lords, and filed this
Not
application.
that. Look at this and also the suit,
Yes, ma'am.
that the judgment.
Yes.
So if you look at page number 2, the Tippamma and all her Narayanappa and all the family members of Narayanappa are here at page number 2.
Yes, my lords. Yes,
Then-
yes. It
yes,
is.
then please wait. Balappa Reddy.
Yes.
He has 9 children. Balappa Reddy, Prabhavati, Krishna Reddy, Jaishankar.
Ramanjanappa, Jaishankar, those are the sons of Balapareddy.
Last is Gururaj Reddy.
Yes, yes.
Gururaj. And Manjunath, yes. Then the third is, then who is this Raghu?
Raghu and 6, my lord. 6, serial number 6, Venkatesh B.
That is the purchaser. He is the purchaser for other property.
Raghu is the purchaser.
Purchaser.
Jayaprakash Reddy?
He alienated Jayaprakash Reddy. Raghu alienated Jayaprakash Reddy and Raja Reddy.
Then you are also a party, Venkatesh B.
I'm not a party, sir.
I'm looking at the judgment and saying that Venkatesh B is at page number 6 of the judgment. You have a copy of it?
So.
Look at it, page number 6.
Yes, madam.
You're there in the suit, Venkatesh B.
Now, subsequently, he inserted.
Whatever it is, you are a party to this suit. What has happened? What was
That is different partition. That is survey number 12 of Kalsnalli village, not this properties.
So for each property,
partition
for each property, one partition suit will be filed.
No, I see, I am not aware of that. Not aware of that.
Yes. So, where is the decree?
The suit has been dismissed, my lords, and an appeal has been preferred.
What ground it is dismissed?
My lords, I may kindly be permitted to read a paragraph of the WP orders in 29778 of 2017. The same has been produced before this. It is very clear, and the relevant portion is 5. I may be permitted to read one paragraph.
Let us look at this judgment. What is there before us?
Yes, the same has been discussed, my lords. In the previous round of litigation, same has been discussed.
Yes.
The 29778 of 2017, the first paragraph, the relief is one and the same, my lords. The petitioner's application under Order 1, Rule 10 of the CPC before the City Civil Court is rejected by the impugned order dated 27/6/2017. The suit in OS number 1469 of 2014 is amongst the family members of the deceased Narayanappa. The petitioner Balappa Reddy is no more and his legal representatives have come on record. Now I will draw the Lordship's attention to para 5 of the judgment. In para 5, if there is, this is the operative portion. If there is any decision or any settlement inter se, the next family members in a separate suit, such decisions or even a settlement will have to yield to the decisions of the proceedings amongst the primary members.
How are you understanding what is the judgment of the civil court? Why it is dismissed from this order?
My lords,
For this, you have to see the judgment.
yes, my lord.
Yes, what are the suit scheduled properties and why the suit is dismissed?
My lords, it's discussed in detail, my lords.
It is
because,
not discussed in detail here.
So far as the,
To that, please show, if you're ready, I'll hear the matter or else you come on some other day.
yes, my
Prepare
lord.
and come.
Yes.
No,
This is matter.
should be posted for amendments. 9, this month 9.
This is matter on 17 June. Yes.
Number 5. Yeah, Abhinav Ramanan.
Lord, this and the next matter, my lord, it is settled.
Settled?
Yes, my lord, we have to only
It's
file
not
a.
settled. My lord, it is not settled. It is not settled. There is the appellant has approached with a thought process. I'll just take 1 minute, man. It is a eviction suit where arrears of rent of 3 crores has to be settled. As they are keeping on filing one writ petition, one commercial appeal. Recently, the commercial appeal has been dismissed by the Honorable Division Bench of this Honorable High Court, and they have preferred a writ petition and again taken a stay. In another petition, the court has not granted stay. So the client is suffering from cancer. So out of all frustration, they have come forward for a settlement. He has accepted for that. 10 days back, a compromise deed has been prepared and given to them, giving up the entire 3 crores of the rent and possession to be given. They said in 2 months, possession will be given. All has been already encrypted in the compromise deed. No response from them. This is one more dragging proceeding. The matter is today before the commercial court for pronouncement on arrears of rent. They are going and submitting something there. They are coming and dragging. This matter was listed 1 day before vacation. The court, out of 2 petitions, husband, wife, both are senior citizens, and husband is suffering from cancer. So the court said that we will not grant stay in the second writ petition, which was wrongly granted in the one writ petition. If your lordship may kindly see, he has challenged the same order before division bench and suffered an order. Again, he files the writ petition, takes a stay. Having fed up with this, they have come for 10 days has lapsed. There is no response from them, and they are telling it is settled. I am the petitioner. I am the plaintiff's counsel. I am not aware of any settlement being done except talking and again dragging. The only submission what I want to make, ma'am, my lord, is the other side is a practicing lawyer. He keeps on filing one writ petition or the other, and every petition is dismissed with cost. Still, he doesn't. The Honorable Chief Justice has passed an order in division bench order which is challenged before this writ petition. The Honorable Court has directed them to appear before commercial court and fasten up the process. They again come and file a writ petition and take a stay. So being fed up, the party has no other option, but he has accepted their terms and conditions to give up the entire rent of 3 crores. And that is also they are dragging it. So this matter can be heard and been dismissed. It has to be dismissed. I will make out the ground before this honorable court. The commercial court, today the matter is listed. Again there they will go and submit. Again they will take time there. So they are not settling, they are only talking. I will leave it to this lordship. He is actually undergoing chemotherapy. He is suffering and not even 1 rupee is paid by the other side.
Lord, last night, my lord, the draft was sent to them. Lord, I have the colleague has it on the phone. Only thing, my lord, they have sent a draft. We have sent a draft, my lord. It has to be, my lord, finalized. I am only requesting 1 day's time. Please have it on Monday. I will sit with my friend, my lord, and finalize the terms because.
We'll take it on top of the list on Monday.
Monday, please take it on Monday, my lord.
Submitted by the land council for the petitioner that the parties have entered into a compromise. Land council for the respondent submits that. It is not yet finalized. Council for the petitioner submits that. By Monday, they'll finalize the same and submit before this court. List this matter as on the top of the list on Monday.
Very well. Great. Both the matters.
Both the matters.
I'm grateful.
Cell number 6.
Let them not precipitate here, my lord.
They are taking attendance there. They are not in a position to precipitate. It's only pronouncement of orders there.
No, I'm appealing for the petitioner in this case. I'm challenging the portion of the order is regarding to the deficit in stamp duty, Your Honor. Kindly issue notice, Your Honor, and another connected matter also.
My lords, in 6.1, I appear for the respondents, my lords. In 6, we have no instructions to appear in this matter, my lords. Notice may be issued accordingly.
And what about 6.1?
Connected matter. Same date.
Six
maybe
point
fixed
one
now.
is also regarding the deficit stamp
Deficit
duty, my
stamp
lords. My lord, may
The respondents, does this matter on, list this matter after service of notice to the respondent?
Cell number
Seven.
please, my
seven,
lords.
Yes.
cell number 7. SV Prakash.
Appear for the petitioner, my lords. I'm challenging the order rejecting my application for amendment of written statement.
What is the suit for?
The first respondent instituted suit for
What is this?
partition
Hmm.
against me and the other respondents, my lords.
Party, which year is the suit?
My lords, 18, my lords, 70/2018, 70/2018.
When was this IA filed?
I have filed at the stage of defendant's argument, my lords. I'm the defendant number 4. At the time of argument, I want
What is
to include some,
What is the amendment that you're seeking?
my lords, I'm seeking, in fact, one deceased brother was there, my lords, for the parties.
It's IA, without
Please, my
going,
lords.
we can
Kindly see
understand.
page number 63, my lords, Annexure H.
63.
Please, my lords.
Hmm.
I wanted to include,
Affidavit, yes.
Please,
Let's see the affidavit.
may I read, my lords?
Hmm.
Third para, my lords.
Hmm.
The amount deposited in the bank of name of the deceased Paniraj in the bank, State Bank of India, Kaveri Bhavan branch, CBAB complex, KG Road, Bangalore, so and so, and kindly be ordered to Shirastedar, the Court of Chief Metropolitan Magistrate, Bangalore, to produce the service register nomination details, amount transferred to the account of beneficiary with respect to the benefit of the service of the deceased Paniraj Life Insurance, Provident Fund, KG ID number so and so, and order to furnish account of the amount received from the account of deceased Paniraj by Shri Nagaraj, the third defendant number 3 in this case. I state that if the plaint is not amended, or said there is a mistake, it is a written statement.
Let's see your, the proposed amendment. Come
Let's-
to page 63.
Please, my lords. Schedule, my lords. The defendant begs to submit that deceased Paniraj is employed in court and died without issues. Hence, the plaintiff and the defendants are only class 2 heirs entitled for the assets and liabilities. So, the amount deposited in the name of the deceased Paniraj in the bank, State Bank of India, Kaveri Bhavan, so and so, and kindly be ordered to Shirastedar, the Court of Chief Metropolitan Magistrate, Bangalore, to produce the service register nomination details, amount transferred to the account of beneficiary with respect to the benefit of the service of the deceased
How
Paniraj.
can
Life
this be an amendment to the pleadings? You're seeking a direction.
Please, my lords.
You're
in fact,
seeking a
yes.
direction to produce something.
In fact, the intention was to, my lords,
No,
include
whatever
those.
is the intention, this can't be amendment. That is the reason why the court dismissed?
No, court dismissed on the ground that there is no due diligence on my part, my lords. Page number,
No, you're, yes, please come to that order.
page number 77, my lords. Impugned order. Para number 10, my lords, 77.
Yes.
Para number 10, my lords. As per the above order specifically stated that the amendment application shall be allowed after the commencement of the trial unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement
Court
of.
has, in a mechanical way, all amendment of pleadings is dismissed.
Please,
Even otherwise, that can't be. You are seeking a direction to produce some document by way of amendment.
my lords.
Please come.
Plus, I may be permitted to withdraw the writ petition with liberty to file separate suit
Why should?
for
we
that.
will- We will grant you liberty to file a suit by withdrawing this writ petition.
Please, my lord, because now in fact, he is seeking for amendment of schedule to include those bank deposits and his retirement benefits as.
That kind of a permission can't be granted.
I may be permitted to withdraw.
Memo is filed seeking to withdraw the writ petition. Give the memo, dismissed as withdrawn.
Oblige.
Cell number 8. Kumar,
My lord.
hearing assist.
Petitioner have filed a suit for partition, my lord, wherein trial court has granted
May I seek
interim
for
order, my lord.
passover, my lord?
Trial court has
I
granted
seek
interim
for
order.
passover, my lord. May I seek for passover, my lord, may be taken at afternoon.
The urgency is, my lord.
No, urgency is, you can argue it in the afternoon also.
Much of.
It's passed over. Yes, 9.
Cell number 9. Harun PM.
I challenge an ex parte interim
This is
injunction.
maintainability of writ
Yeah,
petition.
I challenge an ex parte interim injunction order in a partition suit. Lords, I am passing on a judgment of the Honorable Supreme Court, latest judgment, insofar as ex parte orders and challenge in it. I will read the judgment afterwards.
No, what is this maintainability?
Please, my lords. The suit is, the writ petition is filed on an ex parte order, order 39 rule 1 and 2. Kindly see,
Petition papers. were
and
not
the schedule in the plaint, I am not challenging the
will not
39
be maintained,
rule.
but it's the order dated on the file of the in your 64. Which court has passed this order?
The trial court has passed this order, City Civil Court, City Civil Court, Bangalore. Your lordship will get it at page 18, Annexure A. Without assigning reasons
Correct.
that I can challenge it.
No. Against this order where the appeal lies.
Appeal lies, there is no appeal, this is ex parte order. I have to file an application for vacating stay or objections, and the court has to hear the matter, trial court has to hear the matter. MFA is not maintainable against ex parte order. Now, the only remedy is by virtue of the Supreme Court judgment, the writ petition before this honorable court, 227.
Why it is not a remedy, seeking vacating the petition?
No, that will consume time, my lords. Trial courts will take 6 months to 8 months to vacate interim orders. And kindly see how the court has granted an order, interim order, ex parte order. 3 grounds I'll raise, not on merits. I am conscious of the fact that somewhere the line has to be drawn in ex parte. Kindly page 18, my lords. It starts at page 18. Your lordship will get it at page 21. The trial court notes down the contentions in the first page, second page, and kindly turn to page 23, second paragraph, to prove it starts. Lordship got it? To prove the case, the plaintiff has produced encumbrance certificate pertaining to survey number 48/2, dated 8/8/2013. And for the years 1/4/1990 to 31/3/2004, and another encumbrance certificate for the year Sumerian family tree. My lords may mark it. I will show the family tree. 22 people are not made parties. A plaintiff is filed, and trial court notes that family tree is produced. Out of the family tree produced by them, 22 are not made parties. Joint development agreement and deed of consent and confirmation. In these deeds, the plaintiff has not signed to the same, and the plaintiff prima facie shown that they being the legal heirs and the property being the ancestral and joint family property, the share of the plaintiffs has not been given. Straight away, trial court comes to the conclusion, property being ancestral and joint family property. There is no reasoning at all. This is the only reasoning. Now kindly come to the facts of the case. 2 minutes I'll take. Your lordship may kindly turn to the plaint.
Page number?
Page number 93, Annexure D, my lords. Annexure D. Your lordship may kindly see 5 plaintiffs are there. They are the grandchildren. The respondents are their aunts, father and grandfather.
You are a purchaser.
I am the purchaser. Defendant number 15 and 16.
Who sold the property to you?
Their father and grandfather. All the fathers, I'll show the genealogical tree. Your lordship may kindly permit me to, I have collated the genealogical tree produced by them. Your lordship may kindly permit me. I have served a copy on them. I am passing on the genealogical tree. I had passed on earlier also. My lords may kindly see the genealogical tree. The top portion, it starts with Muniamma, Gaurama, Chandamma, then Yellappa Reddy, Gullappa Reddy and Venkat Reddy. They are the grandfather. 3%. They have sold the property in my favor along with the sons, Gopal Reddy, Muni Reddy.
When was it sold?
2004. 1994, I'm sorry, 1994. It was sold by the plaintiff's father and grandfather, both of them. Then the daughters, Yellappa Reddy and Gullappa Reddy and Venkat Reddy's daughters challenged that in a suit. In 2005, a decree was passed by the City Civil Court. Then a deed of consent and confirmation was executed by them, a registered deed.
What is that decree in 2005?
That they compromised the matter, and we paid them 1 crore and odd, and the deed of
Specific performance.
Please, my lord. They had filed for partition. The plaintiff's aunts, this Ratnamma and others had filed for partition. That suit, deed of consent and confirmation, was executed by them in our favor, and we paid them 1 crore and odd, and matter was settled in 2005. Original sale deed was 1994. Now it is challenge after 30 years before the trial court. Trial court doesn't take cognizance. Now kindly see, my lords, who are parties in the suit. These are the parties shown as joint family members in the genealogical tree produced by them before the trial court. Only 5 persons, and along with these persons marked in red color are made parties. Persons marked in green color are not made parties. And also 2 persons, Manjunath Reddy and TV Kumar, father of plaintiff number 4 and plaintiff number 3, they are not made parties. Recklessly a plaint is filed, trial court raises an objection. Your Lordship may kindly keep this and come to the office objection raised in the order sheet, it is reflected.
Yes.
I will not go to merits of the matter. My lords may kindly turn to page 19, order sheet of the trial court.
Page 19.
19, my lords. Plaintiff's counsel present. In compliance of the office objection, the plaintiff counsel filed memo along with family tree. My lords may kindly note it. After family tree was produced, only case was taken on record. Now, how many are parties? Kindly see the genealogical tree produced by them and how many are parties. Page 93 is the plaint.
No, you have stated so.
Yes.
But, yes.
Page 93. Now, that is one ground. Another ground, your Lordship may kindly see the plaint for a moment. At page 93, it starts 100, your Lordship may kindly see prayer in the plaint. Pass a, your Lordship got it, page 100, my lords. First prayer. Pass a preliminary decree for partition declaring that plaintiffs are entitled to respective lawful shares. No share is mentioned. Trial court could not have entertained the suit without the plaintiff mentioning 1/5 or 1/6, 1/9, 1/100. What is their share? In the suit schedule, property bearing survey number so and so.
According to them, that court will decide.
Yes. This is why I have come before this honorable court. The difficulties faced by in a joint development agreement. I have registered with RERA. So many compliances are there. Sanction plan is obtained. I have started construction. My lords, kindly see the urgency for the court. The Supreme Court has said, gravity of the matter, why an interim order is required to be passed, that Supreme Court has taken.
What did they say in the IA? What is urgency?
They kindly see the IA, my lords. No urgency is pleaded.
Where is that?
IA is at page 107. Not to alienate. Your Lordship will get it at page 110. Absolutely no pleading, my lords, regarding urgency.
110.
110. Third paragraph. I submit that the suitable property is a joint family property in which I have a lawful and rightful share. The same is more fully described in the schedule annexed to the plaint. I submit that defendants without any manner of right, title, or authority are attempting to alienate, encumber, or otherwise create third-party rights over the suitable property to the detriment of my rights and interest. I submit if the defendants are not restrained by an order of this honorable court, they may proceed to alienate or otherwise deal with the suitable property, which would seriously prejudice my lawful.
About the sale deed?
No, nothing. In the suit plaint, they have said regarding the sale deeds. 1994 sale deed is challenged in 2016, the 32 years thereafterwards. 1992 sale deed.
No, they have questioned, they have challenged that.
Kindly see that challenge, my lords. Another prayer, the Lordship may kindly see that prayer.
My lord, I pray for a short accommodation. My lord. I'll file my objection and argue on.
This was moved earlier to vacation. They took time.
I will stay the operation of that order.
My lord, because order has been
Blatantly on the face of it, what is this? What is how the plaintiff is filed?
Argue on the merit.
How the court can grant injunction?
My lord, because it is
the property which is sold in the year 1994. 94. There is urgency of alienation in the year 2026.
My lord, we have a merit. We have a evident records to show before this.
This is an abuse of the process.
I will argue 2 days.
Consider that.
Vacation court took up the matter. They took time.
My lord.
Then counsel appearing for the petitioners.
My lord, one submission, my lord. My lord, the trial court passed an order not to rent the property. They are already constructing. Only thing is they're not supposed to create third parties.
That kind of an injunction order shouldn't stand not even a minute.
My lord, 2 days time may be granted. Monday I will file my application. I will argue on the case.
My lord, they are putting up a board in my property, painting the walls that there is an injunction order. I can't.
Status quo. Considering the submission of the land council, status quo will it continue to your benefit?
Status quo means it will complicate the matters, my lords. Without a stay, it will complicate. Status quo, they will come and put the board again. They are local villagers. They have sold in 94. Now I am new to that area.
The respondent shall not proceed the counsel for the petitioner submits that without having filed a family tree before the court, without making the necessary parties
22 people.
to the suit, they filed a suit. And even the plaintiff does not disclose what is the
Share they're
what is the
entitled.
share they're entitled or they're seeking for. Further, no urgency is mentioned in the IA, and the court, without even recording any finding with regard to the prima facie case, balance of convenience and irreparable loss, has granted the injunction. It is submitted that this matter is moved before vacation.
This court, earlier to vacation, they took time. Vacation court, they took time.
They moved this matter before vacation, and even during the vacation, this matter came up, but the respondents have sought time. It is submitted that the courts cannot pass, the court ought not to have passed such an order. Such an order, an order of ex parte injunction, injunction with injunction. It is submitted that the property which is purchased in the year 1994 and for 94, and where the petitioner is making construction by
Joint development
obtaining
agreement.
necessary permission from the
Statutory authorities.
From the statutory authorities. Now, by virtue of this order, the respondents or the respondent plaintiffs are interfering with the position of the petitioner.
Construction trial court has not granted as of now, but not to alienate it as stated there. That will create impediments.
Order,
One
they're trying to
submission.
interfere with the petitioner's position.
One submission.
And counsel appearing for the respondent submits that if the matter is adjourned, they'll file their objections and argue this matter. The entire material is before this court, basing on which an injunction is granted by the trial court. No further objections are required to be filed in a petition, in this petition, as this court is only concerned with the material which is basing on that is filed before the court and basing on which an injunction is granted. If the petitioner wants to file the objection, it's for the petitioner to file. Next further, looking at the manner in which the order is passed by the court, which is not mindful of the settled law, and the time and again the directions issued by the High Court and the Honorable Apex Court, the considered opinion of the court, the order, the impugned order has to be stayed accordingly.
I'm grateful, my lord.
Stay of all further proceedings pursuant to the order dated so and so. Does this matter? When do you want?
Well, next week, my lord.
Does this matter on 16th?
My lord, I pray one submission. My lord. At least status quo may be maintained.
No, no,
At
no,
least if
no.
they create third party rates, my rates
Today
will be
also my
affected.
learned friends sought for
These
time.
partition suits and these kind of, we can't, the courts can't be, like parties and new spectators to this.
Sir,
I'm
number
grateful.
10, Sir Raju P.
Yes.
The application, well, the suit for partition was filed by the first respondent. So the suit came to be decreed holding that she is entitled 1/5 share. Plus the respondent number one, the plaintiff filed the final decree proceedings. Well, in the final decree proceedings, we entered appearance. But during the pendency of the FDP proceedings, the plaintiff filed an application seeking direction against the present petitioners to deposit the compensation amount.
To deposit the?
Compensation amount towards the acquired land which the writ petitioners were received.
When did you receive the compensation
In the
amount?
year 2009,
2009.
please,
In respect of the properties which are part of the suit.
please. Now, my lord, we filed the writ petitioners have filed the appeal, my lord, before the division bench of this honorable court. Division bench of this honorable court granted the interim stay. But insofar as drawing the final decree proceedings may go on. But we filed a memo and furnished a certified copy of the stay order. But despite the trial court is allowed the application, directing the writ petitioner to deposit the compensation. But that impugned order is questioned before this honorable court in the writ petition.
Let's have two submissions. There are mainly two properties, Schedule A and Schedule B properties. Schedule A property, I have received a part of the compensation, 6,50,000, and Schedule B property, after the preliminary decree was passed and even the Land Acquisition Authority was a party to the suit, in collusion with them, they have withdrawn the amount. Hence, this order has been passed to direct the respondents to deposit the amount.
That has happened in the year 2009.
2009 only Schedule A property compensation was received by me. That is only a part of it. That is 6,50,000. I was entitled for 50 lakhs.
When was the amount received for Schedule B property?
Later, my lords, after passing of the preliminary decree.
When is that? There should be a date and year for that.
Just
Page number 72, my lord, division bench, my lords, the order of the division bench of this honorable court.
72.
72, my lord. It will be sub judice, my lord, the page 72. In middle, my lord. Oral order on IA number 3 bar 2025. Or the Learned Council appearing on either side. There will be stay of drawing a final decree. However, it is made clear that the final decree proceedings can go on. Accordingly, IA number 3 bar 2025 stand disposed. Now, my lord, the plaintiff's mother, my lord, got married in the year 1952. My lord, plaintiff's mother died in the year 1993. My lord, there was a partition deed entered between the plaintiff and the defendants. My lord, pursuant to the partition deed, she received the compensation. But in respect of Schedule A property. Schedule B property, my lord, the Sagole cheat came to be issued in the year 2003. She claimed that it is a joint family property. That is the question before the division bench of this one. My lord, if the writ petitioner has succeeded, my lord, the entire judgment and decree, my lord, would be set up.
What was the preliminary decree and what were the findings in that with regard to this?
Well, the preliminary decree, the plaintiff is entitled 1/5 share in both the properties, both properties.
And even in this compensation amount also?
Yes,
compensation amount also. Well, FDP filed for making division of the property, not for the compensation. But kindly come to the page number 38 for a moment.
Well, if the land has been acquired by the KIDB, the only option for the petitioner is to seek an application to direct the respondents to deposit the amount, my share, my lords.
Division bench and the Honorable Supreme Court held that the interim relief always should be akin to the main relief. My lord, kindly come to the prayer, my lord, in the FDP proceedings.
So ultimately, all these aspects about your entitlement and other things are now subject matter before the division bench.
My lords, they have filed it after a delay of 3 years. It has not been admitted yet. After a delay of 1,000 days, they have filed it. I don't know how they have got an interim order.
The interim order is granted.
I understand, my lords, and even I have filed a memo of calculation, which they have not placed on record. I'll give me a short accommodation. I'll place it on record, my lords.
In the meantime, my lord, the remaining respondents.
No, my lords, just me give it to a short accommodation. Keep it on Friday, my lords.
Accommodation not possible. We'll say that when counsel appearing for the petitioner's office, there is an order in the order with the division bench in the.
My lords, staying up a final decree has been drawn. We are requesting them to deposit in the court. We will not be filing applications to withdraw the same.
That has to be ultimately decided. Why should he deposit now?
My lords, or else they'll utilize all the amount, my lord, or else they don't. I don't have any other remedy available with me.
That is RFA.
Please.
It is submitted to the division bench as in the division bench in the RFA has passed an interim order.
Lords, they have stated clearly that final decree proceedings can go on, my lords. This is the only option, my lords, for the final decree proceedings to go on. Staying up of this.
What will happen is this amount when they have received.
My lords, after the.
Long back.
Recently, my lords, 3-4 years back, after the suit was decreed.
When was the suit decreed?
Suit was decreed in 22, my lords.
1/4/2022.
Then when was this appeal filed?
Appeal was filed in 25, my lords. I'll just come. 26, I think, 26, my lords. RFA 1456 of 2025, my lords. They contested the application. In the meanwhile, when they didn't get any favorable relief there, then they filed this appeal, my lords, after a delay of 3 years.
That section 18 of the Land Acquisition Act is clear. My lord, if she has any right.
1/5 share is directed to be deposited.
Yes, my lords. 1/5 my share I'm asking to deposit, nothing else, my lord.
My lord, 18 of the Land Acquisition Act. My lord, if she has any right, my lord, she has to make a reference before the land acquisition officer. Or else, my lord, during the pendency of the suit, she can file an application.
So, in the light of this, the judgment and decree in the partition suit, it is said that she is the owner of the share, she is entitled for 1/5 share. Why will in the appeal in the reference, the civil court will decide now?
My lord, 1/5 share, my lord, if the, my lord.
1/5 share in the property which is acquired and compensation is given, she is entitled.
My lord, she was, my lord, 2000, synopsis, like, kindly come to the page number 1, my synopsis.
Yes.
My lord, synopsis, page number, my lord, serial number 3 for a moment. 25/8/2008, the KDB authority issued the final notifications. My lord, in respect to survey number 98, 4 acres, survey number P1, 1 acre, 5 guntas. These are the subject matter of the suit.
My lord,
My lord,
subject matter of this suit should be decided by the Honorable Division
9/7.
Bench, my lord. This is not subject matter of this writ petition, my lord. They are purposefully deviating the
Kindly
court,
come
my
to
lord.
next serial number, my lord, serial number.
You have received the compensation.
9/7/2009, she received the compensation, my lord, 6,20,000 are share pursuant to the register, pursuant to the, sorry, partition deed.
My lord, that is with respect to Schedule A.
What is the 1/5 amount will come to how much?
My lord, 1/5 amount, my lord, they calculated 2,58,75,000.
So,
1/5 share, it will come to 51,75,000.
whatever that amount, that 6 lakhs or whatever, deduct that and remaining you pay.
My lord, that is with respect to Schedule A property.
My lord, the amount, my lord, the total compensation amount, my lord, they are the farmers, they have received the compensation, they have utilized it. My lord, even if assuming, my lord, she is entitled for the compensation, my lord, 51 lakhs. My lord, if I failed before the division bench, well, certainly they are entitled to execute it. My lord, it will be sub judice. My lord, there is no.
Sub judice. Court has not stated the final decree proceeding. This is part of the final decree proceeding.
Please, my lord. Now, my lord.
Only judgment is stated.
My lord,
Only
please.
for passing of the final decree.
My lord, the interim, my lord, the main prayer, my lord, in the FDP proceedings.
If the division bench has stayed the entire final decree proceedings, that is a different aspect.
Please, my lord.
Court has not stayed.
Well, I am not.
The executing court can go ahead with the final
Well,
decree
not
proceedings.
FDP proceedings.
The final decree proceeding, as per the final decree, preliminary decree is entitled for 1/5 share, and whatever amount you have received, court has.
My lord, that amount, my lord, that if I failed before the division bench, they certainly she is entitled.
Received after the preliminary decree is passed, and you come to the court after 3 years.
My lord, my lord, if the order is enforced.
Request of land counsel for the respondent. Let's this matter on 1st of July.
The remaining respondents may only entered for caveat.
At the request of respondent number.
One minute.
One,
Not
this is
one
matter on 1st of July, notice to the other respondents.
Please.
Serial number,
Much obliged.
serial number 11.
My lords, and for the petitioner, my lords, the petitioners are the plaintiff in the trial court, my lord. The suit has been filed and for suit for relief of partition and separate possession, my lord. The operative portion of the order is at page number 22, my lords. The IA
What
number,
is IA?
IA number 1 filed under order 39 rule 1 and 2 of CPC is not considered by the trial court, my lords. I have produced the judgment.
Where is that? Where is the page number order?
22, my lords.
Issued suit summons to defendants along with by 8/7/2026. Yes.
My lords, in the last date of hearing, my lords, I have given one judgment, my lords. In WP number 35488, my lords, in vacation bench, my lords.
Yes.
In the coordinate bench of this honorable court, it is held that, my lords, in paragraph number 7, my lord, in the similar case, my lords, IA filed under order 39 rule 1 and 2 has not been considered by the trial court, my lords. This honorable court has held that, my lords, when the application is filed under order 39 rule 1 and 2 of CPC by the plaintiff along with the plaintiff seeking an ad interim ex parte order, the temporary injunction, it is become the duty and the obligation of the trial court to consider the same and pass the suitable orders, either granting,
given a reason. Court has given a
granting
reason
or
that
rejecting, my lords.
interim injunction at this stage without hearing the other side can't be passed. That's what the court said. The matter is coming up on 8/7/2026.
My lords, it is held that, my lords, the IA should be rejected or allowed, my lords.
Notice shall not be issued.
My lords, this coordinate bench of this honorable court has held.
Take that.
Starts from paragraph number 7, my lords.
Want the same order?
Yes, my lords.
Please come. Agreed with the orders passed in. The petition is before this court. Question the order dated 10/4/2026, whereby the court, without granting injunction, has issued notices to the, issued summons to the defendants, along with emergent notice on I number 1 to defendant number 17, and returnable by 8/7/2026. Then comes to the petitioner submits that when an application is filed, and order 32 rule 2 of the CPC. When the application is filed, I number is 1 is filed, and order 39 rule 1 and 2 of CPC seeking an order of injunction against the defendant number 17, restraining him from alienating the suit to scheduled property to the disposal of the suit. It is submitted that if the petition is not entitled for any relief, the court ought to have dismissed ought to have passed an order on that. But the court cannot court cannot issue summons to the respondent. She has relied on a coordinate bench judgment of coordinate order passed by a coordinate bench of this court. WP number 35488 of 2025. In case of Dalita Vivida Gramodyoga Kaigarika Sahkara Sangha Niyamita versus Samata Sainika Dal SST, arising out of WP number 35448 of 2025 dated 9 December 2025, whereby a coordinate bench of this court has passed the following order: 6, 7, 8, 9 extracted. Relying on this, it is submitted that the matter may be remanded back to the trial court to consider the application on the IA number 1, considering the submission to the council, and in the light of the order passed in WP number 35488 25 referred supra, the matter is remanded back to the trial court, directing the trial court to consider the IA 1 filed by the petitioner in accordance with law, and the court shall consider the application in accordance with law. Yes.
Cell number 12 from Shekaraya RP.
The respondent, my lord, filed suit for specific performance of agreement of sale, and the suit came to be decreed partly, directing to refund the amount against Quatrapa, my lord. But after the death of Quatrapa, my lord, the execution case has been filed, wherein the legal heirs entered appearance and filed application, protest application, my lord. That application came to be rejected, against which appeal has also rejected, my lord. In the meanwhile, my lord, since the joint family property, my lord, we have filed suit for partition and separate possession. It came to be decreed, my lord. My lord, thereafter, my lord,
Is also there in the,
please, my lord.
this agreement property is also there in this.
Yes, my lord. The same property, my lord. Thereafter, my lord, the property was put for public auction, my lord. We filed application to to set aside recall the order of sale and proclamation. My lord. That application came to be allowed. Against which, my lord, the respondent filed appeal. Appeal also dismissed, my lord, against which writ petition was filed before the Assam court, my lord, in the year 2018, my lord. My lord, when the matter was pending before the Assam court, my lord, the very executing case itself, my lord, dismissed for non-prosecution, my lord. Against which they have filed appeal. Appeal is also dismissed, my lord. Without bringing to the knowledge of the Assam court, my lord, the Assam court, my lord, since it was not brought to the knowledge of the honorable court, my lord, the Assam court, my lord, your lordship kindly turn to the order passed by the Assam court, my lord. At ink page number. Annexure E, my lord.
Page number.
Page number 67, operative portion of the order is at ink page number 74, my lord. This dismissal of the execution petition, which was dismissed, was not brought to the knowledge of the Assam court. The Assam court, my lord, directed the respondent to participate in the public action, my lord. When the execution petition itself is dismissed, the question of directing them to participate in the public action, my lord, does not arise. Therefore, thereafter, my lord, after revival, my lord, we received notice. But pursuant to this order, my lord, executing case was revived and issued notice to the petitioners, my lord. We filed application. Again, the order was passed for public auctioning of the property, my lord. We filed application and argued the matter, my lord. But however, my lord, based on the earlier dismissal of the application, which was dismissed prior to filing of the suit, my lord, avoiding that, the application is not made. But when the execution petition itself was not there, and it is not brought to the knowledge of the Assam court, my lord, they misrepresented the court and obtained the order.
So what is to be done with that?
My lord, now, my lord,
You have to file a review, or you have to do something with that order.
my lord, now, my lord, in view of the urgency, my lord.
No urgency. When there is an order,
Yes, my lord.
we can't, there is no urgency, and this court cannot pass
No,
any
my,
orders.
no, my lord, my question is that when the executing petition
Now,
itself was not there,
any order is passed
Please,
pursuant to this.
I have to
order.
seek review the order passed by the Assam court, my lord.
Notwithstanding and not looking at this order, this court cannot pass any other order.
But I have produced that order, my lord. This order passed by the Assam court, my lord, I have produced. That is the annexure, my lord.
I've seen that.
Yes, my lord. When this order was made in the year 2025, whereas the execution petition itself was dismissed in the year 2020.
That I understand, Mr.
Please,
Counsel.
madam.
What the court can do now with this order?
No,
Why don't
madam.
you file, instead of filing, before filing this writ petition, you should have filed the review against this order before the.
But now only we came to know, only when the we have received summons from the executing court, my lord, we came to the knowledge.
I'll adjourn this matter, you file a review.
Right, it may be very difficult because my lord, date is fixed.
So please understand, the court cannot pass any order. Whatever
Now
it
the
is,
case is
suppression,
posted for
misrepresentation,
confirmation of sale.
notice of that court. We can't do anything.
Well, now the case is set down for confirmation of public action.
If you can point out something basing on that order is illegal, we can understand. Basing on an order passed by the High Court,
Yes,
if
ma'am.
that is the order passed, how can this court find fault with that order?
Find and it's fine, my lord. By misrepresenting, my lord, the
So
orders
that's why
have been
at least
obtained.
now,
My lord,
better file a
to
review.
protect my right, my lord, for a short while, my lord.
No, it can't be done. Yes, this
It
is
may be
matter.
deferred for 2 weeks, my lord. In the meanwhile, I'll
This is matter on 30th.
that's it. Observation, my lord, to
It is submitted that it is submitted with the land counsel to the petitioner that.
annexure E.
Where is that?
Annexure E, my lord. Dismissal of execution petition. Page number 67.
it is submitted that the, by suppressing the facts, respondents have obtained an order in WP number 111090 of 2018, dated 19th March 2025. Pursuant to the said order, the impugned order is passed. It is submitted that the petitioner's interest may be protected. Now they are going to conduct the auction.
Please, madam.
What is that they are going to do now?
Madam, I have to file review petition, madam. Now the case is shut down for confirmation of public action. madam.
The, as a matter is, the case set out for confirmation of the public auction. Confirmation of the auction. And the order petition, this is an admitted fact that the petitioner has not sought for any review of the order passed in WP number 111090 of 2018, dated 9th March 2025. In that view of the matter, this court cannot pass any interim order in this petition. The only remedy that is available to the petitioner at this point of time is to seek the review of the order if he is aggrieved by the same. This is matter. Petitioner seeks time. This is matter on 30th of May.
Cell number 13. Government advocate.
They represent the state, my lord. State has filed the writ petitions, my lord. In all the 4 writ petitions, my lord, the writ petitions arise out of execution proceedings, my lord, wherein, my lord, the state is the judgment debtor. My lord, the order impugned under these writ petitions is, my lord, the order accepting the memo of calculation filed by the decree holder and rejecting the memo of calculation filed by the state, my lord. So therefore, my lord, the writ petitions are filed.
What is the difference between both the calculations?
My lord, the calculation is huge, my lord.
Take in this first case.
Yes, my lord.
In WP 15529.
My lord, the calculation, memo of calculation filed by the decree holder exceeds the, my lord, order passed by the division bench of this honorable court. So therefore, I'll point out it, my lord, in 2 minutes, my lord.
It is the first matter.
Yes.
Yes.
Lord,
Let's come to that order so that we will understand what is your calculation and what is their calculation.
The impugned order is at, my lord, page 32, my lord.
Yes.
Page 32, my lord, it starts
Where
at
it mentions about the amount.
My lord, nothing is mentioned about the amount, my lord, in this order.
However, the Derriere is not disputing that is liable to pay rupees
Yes.
9,19,954.
Yes, my lord.
According to his own memo of calculation, by excluding so and so. In view of the above, there is no impediment for the admitted amount.
Yes. My lord, according to us, my lord, the admitted amount, entire amount has been paid by the state, my lord. But the thing is, my lord, kindly turn to page 34, my lord. Page 34.
Yes, I am at 34.
Please, my lord. Wherein, my lord, accordingly, memo of calculation prepared by the decree holder is accepted and the memo of calculation prepared by the JDR is rejected. Order, my lord, operative portion. JDR is liable to pay compensation amount, including interest on solatium and additional market value. My respectful submission is that, my lord, on interest on solatium, the reference court had already deleted that portion of the order, my lord, without noticing that, my lord. The memo of calculation filed by the decree.
How can such a vague order be passed without even mentioning what is the amount,
Yes,
what
my
is
lord.
that, what is the
Completely vague
solution?
order, my lord. And in addition to that, my lord, earlier, my lord, what had happened was, it pertains to a land acquisition, my lord, at Ranganatittu, my lord. It's a bird sanctuary, international bird sanctuary, my lord. In respect of which, my lord, in order to develop that, my lord, the lands were acquired, private lands were acquired. And the land acquisition officer determines the compensation, my lord, against which, my lord, a reference was sought for before the reference court. And the reference court, my lord, fixes the compensation at rupees, my lord, 30,49,200 per acre. Then, my lord, in that reference order, my lord, kindly turn to, my lord, page 68, my lord, is the reference court order. Page 68, the operative portion is at bottom, my lord. The market value of the acquired land is fixed at rupees 30,49,200. Then, my lord, per acre and rupees 33,600 for coconut trees on the land.
No, forget
Then-
about all this. Please come to your calculation memo. Where is it?
Please, my lord, it is at annexure N, my lord, page 176.
Yes.
Page 176, my lord. The first column, my lord.
What
The-
is this?
My lord, this is first, my lord. As per the award rate, acres rupees 30,49,200. My lord, for a moment, my lord, kindly turn to page 178, the memo of calculation filed by the decree
No,
holder.
no, I'm not on that.
Please.
Now you please tell, as far as this case is concerned,
Please.
this is, who is the
According
party?
to us, my lord, 9,19,950.
Court also said.
My lord,
That's what the court also said. That is an admitted amount.
no, my lord.
Like-
No, my lord. The court has taken the memo of calculation filed by the DHR as accepted.
According,
My lord, in,
no, according to you, what is the amount?
my lord, the per acre it is determined as 30,49,200. In the memo of calculation filed by the decree holder, it is counted as 40 lakh rupees per acre. What had happened was, my lord, after the reference court order, the landowners preferred,
Here all this, once a respondent enters it.
Lord, the difficulty is this, my lord.
Stage, now
Yes.
at this stage, what is your calculation memo? According, as per that, how much you need to pay?
Yes, my lord.
Court has also recorded that you have accepted that 9
Yes.
lakhs and odd is the amount.
Yes, my lord.
That is accepted amount. And as per the accepted amount, court has
Not, my
passed
lord,
order.
means it has accepted the memo of calculation filed by the decree holder. That is the whole problem, my lord.
No.
Your lordship may kindly turn to
That's not the order. Please come to the order again.
page 34, my lord.
34. Yes.
34.
please.
Accordingly, memo of calculation
However,
prepared.
JDR is not disputing that. Page 34 bottom.
Please, ma'am. My lord,
However-
not that one. Earlier to that order, my lord, I am reading the order of 29/11/2025.
No. Anyhow,
Yes,
it is, this also we have to consider.
Yes, ma'am.
JDR is not disputing that he is liable to pay 9,19,954. So then the court said, as they are not disputing, that amount the court has passed an order.
No, my lord, not on that, my lord. My lord, kindly make 34, my lord, at the top of the page, my lord.
Yes.
View of the above facts and rulings and my humble opinion, the present DHR is entitled to interest on the amounts of solatium and additional market value. Accordingly, memo of calculation prepared by DHR is accepted and memo of calculation prepared by JDR is rejected. In view of the above, this court proceeds to pass the following order. So therefore, my lord, on the basis of memo of calculation filed by the DHR, it is proceeding. That is absolutely wrong because of this reason, my lord. My lord, soon after passing of the reference court order,
Let's not go into that.
my lord,
Whether
that
it
is
is
the,
accepted amount of 9,19,000.
that is all paid, my lord. According to us, my lord, the entire amount as agreed by the state, my lord, that is already deposited and paid, my lord, to the landowners.
Where did you say so?
My lord,
Where did you say so that it is?
my lord, in the memo of calculation itself,
Then
the entire amount paid is also, my
is
lord,
that,
stated.
why would the court say that it is an admitted amount that you have to pay an amount of rupees 9,19,000?
My lord, now the court is proceeding on the basis of the memo of calculation filed by the DHR. That is the problem, my lord. Your lordship may kindly
I
turn
think-
to my lord.
Mr. Gandhi,
Yes, my lord.
please understand, forget about what the court did.
Yes.
I'm really not interested to know that.
Yes, my lord.
I'm only asking you a simple question. According to you, what is the amount to be paid to this petitioner, this respondent? And
My
where
lord-
did you say so?
Yes, my lord. In
And
the,
to show me a piece of paper
Yes.
to show that you have already paid. That's it. If it is not, you have to pay that admitted amount of 9,19,000. That I will not interfere.
yes, my lord.
Yes. So please clarify that.
My lord, this is memo of calculation at page 176, my lord.
Yes.
The amounts, my lord, paid, that is all, my lord, mentioned in the memo of calculation.
Yes.
So
Show me
according-
where is the balance amount.
My lord, the balance amount is at page, my lord, 177, my lord.
Yes.
9,19,954.
Yes. So that is the admitted
ma'am.
amount according to you. But you are saying that is already paid. Where is it
Yes.
paid?
My lord, annexure Q, my lord, page 179, my lord.
179? Yes. Yes.
Total amount payable is, my lord, 49,70,654.
Yes.
That entire amount, my lord, is paid, my lord, according to our calculation, my lord. Now that, my lord, the attachment warrant has been issued.
We are only concerned with the memo of calculation that
Yes.
you have paid before the court.
Yes, ma'am.
And you have paid before you were placed the memo of calculation
Yes.
saying that so and so more amount you have to pay. How can you say that we have already paid that amount?
My lord, subsequent, this memo of calculation is dated 18/10/2025, my lord.
You see, on that only the court
Yes,
has recorded the finding.
My lord, my lord, my statement may be kindly recorded, my lord, that we have paid the entire amount as per the basis of memo of calculation filed by the JDR, my lord. That is the instructions, my lord, which I have got.
He can't give that kind of an instructions to you because there should be.
My lord, subsequent to that date, my lord, that is.
Court records a fine. You
Yes.
say you have this calculation, they have a different calculation.
Yes, ma'am.
According to them, solution and all other things have to be
Yes.
paid. You have already paid.
Yes.
And you file a memo of calculation before the court saying that 9 lakh and odd has to be paid.
Yes, ma'am.
And just like that, now you show some statement saying that everything is paid. Pass over.
Please, ma'am.
14,
For petition,
14,
appearing for petition. Well, petitioner and respondents are brothers.
Yes.
Well, they have partitioned the joint family properties long back on 10 to 1984. When the subject property, the present property was left out for the reason that it was agreed to be purchased through one Basuraju. Sale deed was not executed and it was not registered for the reason that there was an act which prohibiting the consolidation of land holdings. And in the partition deed, it was agreed that in case if the sale deed is executed in favor of the family, it has to be divided between the petitioner and the second respondent. If it is not, sale deed is not executed, it should be enjoyed by both petitioner and the second respondent. By suppressing that fact, the respondent number 1 has filed OS 121 of 1999 at annexure A, page number 14. This notice was not been duly served to the petitioner.
What is the suit for?
Suit for permanent injunction. Page number 20.
Against you.
Please, madam.
Against you.
Against me. Page number 23 may kindly peruse for a moment, my lord. One para judgment has been passed. Para number 23. Page number 23, sir.
Yes.
Peruse the plaint averments, Xerox copy of the documents, and decision reported in ILR so and so. After perusal of the same, I feel plaintiff is entitled for decree as defendants have not filed their written statement. That without examining the material, what is the nature of the land, only on photocopies of the.
Are you questioning this order?
We have not questioned.
So then we cannot go into that.
Subsequently, we have filed a suit for partition.
Yes.
So partition suit was dismissed. We have filed RSA. The RSA is pending before the Honorable Court. Suit was dismissed only for the reason that earlier there was a judgment against the petition. RSA is pending. RSA is at page number 96. Meanwhile, my lord, respondent has filed an execution petition. In the execution petition, a police protection is ordered against the petitioner. That order passed against the petitioner at page number 118. I have challenged.
What is wrong with that order?
My lord, since the suit for partition is pending, so police protection cannot be.
Appeal is pending. Appeal is pending.
Appeal is pending.
There is no interim order in that.
No interim order.
Then what is wrong in passing this order?
My lord, for limited purpose, I have filed this writ petition on page number 118. My lord, I understand, my lord, as per the final order of the execution petition, I have to file an appeal, execution appeal. But as far as giving police protection is concerned, my lord, that is not justifiable. Hence, I have filed this writ petition. Page number 118.
Yes.
Petition filed by the DHR is hereby allowed. Office is hereby directed to issue intimation to PSI Kudur police station to give police protection to DHR when necessary. My lord, by virtue of this order, they are removing the standing trace. So before the partition suit is decided, final adjudication. For that limited purpose, so Against the order of police protection, I have filed this writ
Go
petition.
to the RFA where the matter is pending. Go there, ask
And
that
also
court.
this, against this order, appeal is maintainable, my lord, as far as the final order is concerned. As far as police protection is concerned, my lord, such a protection cannot be given against the co-personal.
It is not a co-personal property. It is already, it's a different suit for injunction. It is a different suit. When partition suit is already dismissed.
That is only an ex parte order, only cryptic order has
You
been
didn't
passed on.
question that order.
Yes, yes. I
How
understand.
can you file this writ petition? Please come.
My lord, we will file appeal against this order, my lord. Execution appeal is maintainable before the appellate court. We will file.
Land counsel for the petitioner. The present writ petition is filed questioning an order passed in execution number 20 of 23 dated 15th April 2026, whereby the court has granted police protection to the
And allowed the execution.
allowed the execution petition and granted police protection to the respondent herein. Land counsel submits that. Yeah, they have an appeal against this order. And the writ petition may be disposed of giving liberty to the petitioner to avail the remedy. Accordingly, the writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy in accordance with law. Yes, next.
Cell number 15, Moment Advocate.
Same matter? Yes, pass over.
Cell number 16,
Please. This was a matter.
Prabhakar.
The principal issue is there was an interim order of status quo granted against the defendants. During the pendency of the suit and during the pendency of the interim order, the property comes to be alienated. Now I learn of it on 27th or 28th of April. Therefore, I approached the vacation court. Of course, my lords, I commit an error. The first application I filed before the vacation court is not sufficiently detailed. Therefore, the vacation court dismisses it. Then I file a suit. That suit is misconceived. It is not maintainable. It is withdrawn. Then I file a detailed application before the vacation court saying there is an interim order. That interim order is violated. There is a foundation stone laying ceremony by the purchaser who will now construct an apartment building there and sell the properties. Despite this, my lords, the Honorable Vacation Court says your remedy for breach of interim order lies in contempt proceedings. Now, my lords, there are always two remedies. One is to, if further third party rights come to be created, then I'll be left high and dry. That, my lords, are the facts. If your lordship will kindly see the order. The order your lordship will kindly find at page 46.
We'll order notice to the respondent. Instead of all this, the respondent is before this court. We'll tell them what to do or.
Please, my lords. May I?
Notice to the respondent's petition is permitted to serve the hand summons on the council
Please,
appended
great.
by the respondent.
So grateful. So grateful.
Cell number 17,
Yes.
G. Balaji Naidu.
This matter was heard on Monday, my lord, where my lordship has directed to list on yesterday, with regard to matter is pending before the appellate court, where my lordship has
This is
been.
a copy of the order.
It was listed for
The appeal.
8-9.
On the day before yesterday, a submission was made that commercial appeal will be moved, and it was listed. And my lords, they kindly look at the order sheet.
For the appellant, at his request, list on 8-9.
They appear before the appeal court in commercial appeal before the lordship, before Chief Justice. When it is listed, my lords, they seek adjournment, and now they come before this court, and now they say they will move a commercial appeal. That is the conduct of my lords, the petition.
I'm just making a submission.
And
my
he's a
lord.
tenant, my lords.
I'm not
20
appearing in the
lakhs.
appellate court, my lord. I'm
He is a
only.
tenant due in a sum of arrears is 20 lakhs. Eviction order is already affirmed by even the my lord's appellate court. Now, when the
What is questioned before this court?
Question before is, my lord, page number 16, my lord.
What is it?
That is delivery warrant, issuance of the order of issuance of delivery warrant by the executing court.
Pending appeal, in the pending appeal, you will not have an interim order and you will question it by way of this.
Interim order was only to the limited, my lord. I agree, my lord. Only to the limited extent.
No. You can't have this simultaneously.
My lords, only endeavor is,
No endeavor. You have to go, you have whatever relief you want, you seek before the appeal that is pending
lords,
before the
I am-
division bench.
it is not that I am paying the rents, my lord. Whatever the condition your lordship may impose, I'm ready to.
That condition, division bench will
My lord,
impose.
it's a running PG, my lord. Our students are situated, that's the only concern, my lord. The executing court has not been granted any opportunity to file an objection, and there is an injunction is order is operating against the Decree
All
alter,
that you
madam.
can agitate in the pending
My
commercial
lords.
appeal before the division bench.
My lords,
Not before this
only,
court.
only to the limited extent, my lord, I'm only
No
seeking,
limited extent.
only limited, kindly grant some indulgence may be shown, my lord. I am ready to deposit whatever the amount which has been,
That amount you deposit before the appellate, before the division
before
bench
the,
and seek an order. They will also grant.
some, my lord, some indulgence, my lord.
Agreed with the order passed in. Where is the order?
Page 16, my lord.
Agreed with the order passed and in number 2. In commercial execution case number 1328 of 2025. The judgment letter is before this court. The court has issued a delivery warrant in respect of the scheduled premises if steps taken in the office. It has issued a delivery warrant in respect of the scheduled premises. When counsel for the petitioner submits that he is running a PG and in fact he has preferred a commercial appeal which is pending consideration, and in the meantime if they are evicted that would cause a lot of hardship to the petitioner and there may be a direction. He is ready to pay the whatever the condition, he is ready to comply with whatever the condition this court imposes while granting the protection. When counsel appearing for the respondent submits that the commercial suit is decreed and against that an appeal is filed before this court and the same is pending consideration. If the petition is entitled for any relief and he could agitate the same before the commercial court, but he cannot come up before this court filing the present revision and the revision, presented petition, and the same is liable to be dismissed next by having heard the counsels on either side. There is a material on record. A commercial suit is decreed. Against that, the petitioner has already preferred an appeal. If the petitioner is seeking stay of the execution proceedings, the remedy available to the petitioner is to move an appropriate application before the division bench, but he cannot come before this court questioning the order passed in the execution proceedings. This court is not inclined to entertain this writ petition. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies available to them.
My lord, there is already a stay has been granted only with respect to the payment of arrears.
Whatever.
Right.
After lunch.
Lord, serial number 18, next matter, Lord. I appear for respondent number 1. This matter is not pertains to Lord the registration of construction equipments. Wherein Lord the learned AG has argued the matter on some connected matters listed on serial number 100 in third list, Lord. Maybe called along with next week, Lord. We will argue.
The urgency is this, my lord, the vehicles have been already sold and the transportation port.
We'll hear the matter.
Sir. Sir.
Second list complete ಆದ್ಮೇಲೆ
ಕಂಟಿನ್ಯೂಷನ್ ಆಗುತ್ತಾ ಪಾಸ್ ಸರ್ ಕಂಟಿನ್ಯೂಷನ್ ಅಥವಾ ಪಾಸ್ ಆಗುತ್ತಾ
2:30 ಗೆ ಎರಡು ಮ್ಯಾಚ್
ಮೇಡಮ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ತಗೊಳ್ತಾರೆ ಲಿಸ್ಟ್ 3 ಕೋಡ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಹೇಳಿ
ಬಟ್ ಸರ್ ಅದೇ
ಮೇಡಮ್ ಲಿಸ್ಟ್ 3 ಯಾವಾಗ
ಕಂಟಿನ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ ಸರ್
ಕಂಪ್ಲೀಟ್ 2 ಆದ್ಮೇಲೆ ಮೇಡಮ್
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು
Okay. Continuation. Okay.
So last ರವಿ ಬಂದ್ರೆ ಅಲ್ಲಿ ಹಳೆದು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ತಗೊಂಡು ಏಪ್ರಿಲ್. ಅದೇ 3 ಎಲ್ಲಿಗೆ ಲಾಸ್ಟ್
All those 230 matters.
Item 230, list number 3, serial number 19.
Yes.
My lord, I am the petitioner. In this case, the petitioner is a widow. After the death of her husband, she purchased some land near Asan, Alur. And she has got all the mutation, all the revenue records in her name. A watchman of the neighbor land has come and occupied the place, telling that this place belongs to us. And we, based on that, we went to the police station and also approached the Tahsildar and the Deputy Commissioner. No action has been taken. Then we filed an OS before the Alur civil judge. There, 1 and 2, we filed an application also for odd interim protection for the petitioner. There is no record, they have not filed a written statement, no objections, nothing has been filed. My order 1 and 2 under Order 39, 1 and 2 rule is been dismissed. And subsequently, on that, we approached the district judge. District judge, after hearing the matter, they said, okay, you resubmit the application or fresh filing at the Liberty, and they gave permission to file on 22nd of May. Subsequently, on 29th, we filed the fresh application. After filing the press application, after hearing nearly 1.5 hours our case, the case was transferred to the regular bench and it is listed for tomorrow. My submission is they have not produced even a single record. They have not filed a written statement, nothing. And I am the absolute owner. All mutation
Expect now, tomorrow matter is coming up.
at Asan, madam, district court. No, the problem is we want protection because they're already nature.
That will only be considered by the court, Hassan court tomorrow.
Yes.
Whether you are entitled for protection or not.
My humble submission is that give direction, direction to dispose the matter at least at the earliest, and till such time that the odd interim protection may be given to us. Because this is a widow. She is struggling
Matter
last.
is coming up tomorrow. Let the court consider. There is no ad interim protection for a day. Let the court consider.
At least the matter to be disposed at the.
They'll dispose. They'll dispose. Please come. The petition is before this court.
This is OS 348 of.
How can you file a petition like this? And why should we entertain 2025 speedy disposal of the suit?
No, the problem is this. The trial court has not considered we are the absolute owner. The watchman is coming and sitting there.
If that is the case, you will ask for speedy disposal of OS 348 of 2025, which I will not grant.
Yeah, they did not grant.
That order. Yes. Then what is the next relief you are
No, we
seeking?
filed an appeal to dispose the matter as well as to hear on IN.
How come the registry has
to consider.
numbered your writ petition? Order respondents 230 to take immediate steps to remove
No,
unauthorized.
2, 3 and we
Direct
took,
the trial court to dispose of the suit expeditiously.
no, the police came to the spot and they threatened her. That is the reason we went to the police
Can
also.
we find any of it, what you're saying from what you're seeking before the court?
What
What is your writ petition? The writ petition as filed before the court, is it maintainable?
Yeah, it's maintainable.
Then I will say, I am not inclined to grant this order. Then the writ petition goes. You have not even asked for the IA that is pending before the, whatever your pending application before the appellate court to be disposed of.
My lord, I have filed an IN number 2, which is I have mentioned in that. IN number 2.
That, now what is your main prayer?
Main prayer is that.
Look at your main prayer. At page number 8. A suit which is filed in the numbered in 2025 should be disposed of.
Issue writ of mandamus, any other writ or order directing the trial court for speedy disposal of the suit in OS 348 of 2025 of the petitioner annexure A. Now, then order respondent number 2 and 3 to take immediate steps to remove unauthorized occupation of the petitioner's agriculture land and direct the trial court to dispose the suit expeditiously. And that cost of the petition pass any other suit. This is the relief I have sought.
I'm not inclined to pass any orders on this. Please come.
And interim relief I have passed the protection also.
Interim relief cannot be, beyond the main relief. The writ petition is filed seeking the following prayers. The petitioner has stated, the counsel appearing for the petitioner submits that the petitioner's application that's filed for injunction was not considered. Then they moved the appellate court. And it is the case that so far the application
Court,
is not
MA 4 and 5 both, MA application, first appellate.
The appellate court, and it is a case that the matter is coming up tomorrow. And so far the application is not considered. The relief that is sought before this court in the writ petition is seeking a speedy disposal of the suit, which cannot be granted because this is a suit of 2025. And the second relief is to take immediate steps to remove the unauthorized occupation of the petitioner's agricultural land. That also cannot be granted by this court. That can be decided by the court in the pending MA. And in that view of the matter, this writ petition does not survive for any of the reliefs that sought for by the petitioner before this court cannot be granted by this court.
My lord, a small submission. Time frame may be given some time. period within that the disposal of the case.
First of all.
No, the
when you
problem
come
is,
to the court, what are those reliefs you sought?
no, relief is to give that protection for us. Actually,
Why will it
some
be granted?
unauthorized person has come and occupied our place. And there is,
Not a writ petition. This is a petition filed under, the civil matter. We can't grant that kind of reliefs.
no, at least time bound, they can, the speedy disposal can.
Ask for that. You ask for the speedy disposal of the suit.
My lord, I have gone to the first appellate district court. They hear the matter
There is urgency for this matter.
because they
Tomorrow
agree.
matter is coming up, and today morning you mentioned that it is
No,
important.
the matter came up 2 occasions in district court, my lord.
Let it-
And
I'll
then
not-
it is
I'll not-
posted for tomorrow.
I'll not
Some time period can be granted so that.
Thought I will not grant. Yes, let's.
Cell number 99. 99.
Yes.
Yesterday's matter, let's I just verified. Let's junior colleague,
Whatever it is, the
Let's
same
say
advocate
that's
is appearing, you have accepted, and it is not open for you to make any other submissions now.
No,
Let it go on.
please, my only submission, I have, yesterday only, even the counterpart before the learned trial court came to know, when they filed the NOC, the junior colleague was not aware,
Whoever it is, you made a submission. Now, if your colleague makes any submission, it's not.
No, I'm not justifying or I'm not saying we are not made wrong. Also, I only request this.
So, very interestingly, you file this and go before the court and say that I'm ready to comply with the order within a reasonable time.
But that's a one mistake happened because the council was changed and he was not.
Your client has to be,
No,
pay for that.
Mullets, I only request this. Mullets is a case where Mullets 64 lakhs has been ordered to pay. Mullets, the possession has not been given. Mullets, my only request, Mullets, humble submission for the wrong concession made by the council, Mullets, party should not be troubled. Mullets, they are also ready to file an affidavit, Mullets, to seeking an apology. But the mistake on the young colleague, Mullets. You cannot also go and blame me, Mullets, because 2 months before Mullets, the writ was.
Why will the colleague go and submit before the court that we are ready to pay the amount? Will anybody tell that?
No, because what has happened, Mullets, the defendants were continuously
That is,
pressing
if
for
some
compliance.
mistake is there in the order, was it any point of time clarified to the court that it was by mistake such a submission is made?
Even Muller's senior colleague was only yesterday when we confronted and said this is what happened. Muller, he was also came to know this hasn't happened. Well, that's a mistake. Muller, we apologize and we will file an affidavit to that effect. That's a grave mistake on us part, Muller. I'm
Yes,
sorry.
now on the merits of the matter.
Please, Muller. On the merits, Muller, yesterday I just
According to you, it is not a conveyance.
convention. To say a conveyance, Muller, possession has to be delivered under the agreement. If possession is delivered under the agreement, Muller, Article 20 will comes into picture, and I have to pay the.
And she referred to it refers to instrument. What is an instrument is also mentioned.
Muller, instrument is also mentioned, Muller. But Muller, for all those things, Muller, the possession is the important thing, Muller, to attract the Article 20. But if such a thing has happened, Muller, every instrument for every person who entered into an agreement to purchase a property, Muller, he has a right, Muller. Muller, I'll just only request Muller to kindly take one judgment, Muller, may just rely on that.
Pass on.
Pass over, I'm sorry. To say, my lord, in the agreement, my lord, there has to be mention about the, let's page 10, my lord, para 8.
Yes.
Let's Article 5 has been extracted in there.
Yes.
Let's para 9, my lord. The plain language employed in the Article 5E1 does not create any ambiguity with regard to the stamp duty payable. When possession is delivered, if the agreement of the sale of immovable property is in part performance of the contract and possession of the property is delivered or is agreed to be delivered before executing the conveyance, then the stamp duty payable on such instrument would be same as conveyance under Article 20 of the Act. The aforesaid article deals with the two situations. Firstly, possession of the property is delivered under the agreement, and secondly, the possession is agreed to be delivered before the actual conveyance, that is before execution of the absolute sale deed. The contention of the petitioner that prior delivery of the possession which is recognized under the agreement is also covered under Article 5E1. Judgments are referred. I'll just take to the observation part at page 19, para 11.
Yes.
The aforesaid enunciation of the law laid down by this court and the Honorable Supreme Court clarify the legislative intent of the Article 5 of the Act. The delivery of a possession ought to have been determined upon the recital of the agreement to satisfy the condition that the said delivery of the possession is being undertaken in the agreement or being agreed to be delivered before the deed of conveyance in the part performance of the contract. The actual possession of the property before the agreement is immaterial, as long as the said possession isn't delivered under the agreement itself in part performance. In the case on hand, the agreement does not indicate delivery of possession or agreement to deliver possession before conveyance in part performance of the contract, but only refers to existing physical possession of the plaintiff for the suit shall prove. Hence, the duty and penalty paid by the plaintiff under Article 5(2) is appropriate. Last, my lord, conclusion. Para 16, my lords, last page 23.
Yes.
Therefore, in the instant case, it is clear that possession was delivered much prior to the agreement, and there was neither a transfer of possession nor an agreement to transfer possession at a later point before the deed of conveyance under the agreement. Furthermore, the agreement does not contain any clauses to the effect that possession is being transferred under the agreement or is being agreed to be transferred. Hence, the stamp duty payable on the agreement of sale in the said case cannot be considered to be payable under Article 5(e)(1) of the Act. The trial court has my case is also contained. I have to pay the compensation as per Article 5(e)(2), because possession is not been done. One more last judgment, I'll just trouble. Para 3, my lord, page 4. I just read. Para 3.
Yes.
A perusal of the material on record would indicate that the trial court has committed an error in coming to the conclusion that the sale agreement which was insufficiently stamped. In this context, it is relevant to state that perusal of the said sale agreement would indicate that there is no recital content therein that possession of the property was handed over in favor of the purchaser. Further, in this context, relevant to extract the Article 5, it was extracted. A plain reading of the aforesaid provision will clearly indicate that so long as possession of the property which was subject same, but
Yes.
in
Please, Your Lordship, may I request Your Lordship to kindly see the plaint at annexure B in the writ petition, page 36. There are cases that they invested some money, their share, when I was buying the property. In the sale deed, there's no mention of that. In agreement of sale, Your Lordship saw my translate copy. In the end, my lords, they also then they say no, it does not get any right, whereas the definition under 2G of instrument is any right, not necessarily possessive right or any right. And Your Lordships yourself have passed many orders relying on Digambar Vati, my lords, as to how we have to construe the document and gather, my lords. Besides that, my lords, the clear averment in the plaint at page 37, my lords, para 15 and 16. If I read only two portions, my lords, in para at page 32, my lords, of the writ petition, 42, my lords, given 2 pages.
Yes.
Yes. Lords, at page 42 from 5th line from top, lords, part of para 15. I'm reading, lords.
Yes.
On the basis of the amicable division has been made with the common understanding of all the parties, and as per the common understanding, the plaintiffs have entered into the agreements agreeing to sell their identified sites in favor of prospective purchasers. They've relied on this agreement, lords, and along with my objections, I have filed one such agreement which the petitioner herein has sold, lords, basis saying that I am in the possession. And next paragraph is very important. Para 16 notes, the plaintiffs submit that in the circumstances stated above, the plaintiffs are having absolute right, title, and interest of the suit property in view of the agreement dated 3/5/2016, and they have been in joint possession and enjoyment of the same. They admit, my lords, possession. Therefore, my lords, and like the impugned order, my lords, trial court says, what was the need for you to enter into agreement of sale when in the sale deed you don't say I've given money? Therefore, this transaction is under conveyance is what trial court has held, my lords. Therefore, my respectful submission, lords, it's a correct adjudication. Lords, going forward, my lords, your lordship had asked one question yesterday about sending the matter to DR and not the thing, lords. May I request your lordships to think. Lords, the Honorable Supreme Court in this matter has held, my lords, that step, my lords, comes only if the trial court has not exercised, the party has not exercised the right, my lords, under 30, before adjudicating under 34. If the party who wants to pay comes and tells the court, my lords, that I want to go to DR, only in that case, my lord, they can avail that. But having let the trial court pass an order, my lords, then they cannot come back and say, send me to DR. And my lords, may I point out that particular paragraph 4, 8, and 9, my lords, of the judgment. I just... Para 4, my lords.
Yes.
The instant civil appeal, there was another civil appeal, my lords. Sitaram Sethi was Monnappa, my lords. In that, they are compared to that. After perusing the record, we are of the view that the circumstances in which the decision to pay stamp duty and penalty is rendered are different from the tagged civil appeals. Advocate for the appellant contends that the document should have been sent to the district registrar to determine deficit, stamp duty and penalty under section 39 of the Act, instead of the court deciding under section 34 of the Stamp Act. The argument is untenable to the facts and circumstances of this case. Then minutes, para 8 minutes, after extracting other civil appeals. Para 8 minutes. In the present case, the appellant wanted the suit agreement to be admitted in evidence at the interlocutory stage. The suit was filed on so and so. On so and so, the case was posted before the court, and the counsel for the appellant at the trial court agreed to pay proper sufficient stamp duty and penalty in the certified copy of the agreement to sale. In other words, the appellant invited the court to decide under 34(1), 9 minutes. Being so, when the trial court imposed 10 times penalty on the deficit stamp duty, the appellant argued in the High Court that he would pay the stamp duty when the decree of subsidiary performance was granted. In our considered view, the case of appellant is covered by section 34 of the Act, and rightly 10 times penalty is imposed. Further, the appellant, having invited the court, as noted above, cannot now express the willingness to exercise the option under section 37(2) of the Act.
How it is similar to the facts of this case?
Lords, in this case, Lords, when we filed an application to impound the document, that was the state, because the Learned Counsel made a submission that DR could adjudicate. Lords, if you wanted the DR to, because what happens, he can direct, he could have gone, Lords. When I filed application, he can go to 39.
So there was, which article under the Stamp Act would apply?
Lords, 39, Lords. If you wanted to go directly to,
No.
Yes.
Whether he has to pay the penalty.
Yes.
The stamp duty.
34,
and the-
Lords. Yes,
and
sorry.
whether it Article 5 applies or 20
No,
applies.
20 minutes.
That was the question. That was the
Yes.
question to be decided by the court.
Yes, yes.
Once that is decided, then the question of whether he wants to pay it or it will go before the DR is a next step.
Yes, your lordships had asked me a question yesterday that we will remand to DR. In answer to that question, I just got this judgment.
No, that's what I'm also saying.
Yes.
But this judgment and the facts of this will not apply to the present facts of the case.
Lords, that is if your lordships are agreeing to what he's saying, Lords. If that is the case, then I'll labor a little more in pointing out, Lords, how that agreement is the one, Lords, under which the rights are created, and therefore trial court's order under section Article 20 is applicable for conveyance is applicable to the case, Lords. If I may argue on that point, Lords. If I may take the impugned order, Lords. I will not trouble Lords. Trial court has told that agreement, Lords. That agreement, Lords, your lordships were to see.
I've seen that agreement.
Yes, Lords, that is the one, Lords, where they are saying that whatever amount they have invested, if I don't repay them back, either they can go to court to enforce that or they can sell it. And Lords, if your lordships make my object.
No, whether 5 or 20 will apply, I'm not on that.
Yes.
I'm saying.
Yes.
This judgment with regard to
yes.
determination of the stamp
yes.
duty and all going to the DR or by the court.
Yes.
That will not apply to the facts of this case, this judgment. That
Please,
is what I'm
for a moment. Yes, Lords. Yes, Lords.
Yes, I'll pass orders. Heard,
yes.
Reserve.
I have made a compilation judgment. If I may just pass it on to assist the court.
Yes.
I also one judgment, my lord, wherein this honorable court said, even my lord, the learned trial court determined the amount that can be deferred by this register. My lord, that judgment I will give it with you. I'll just. Yes. Grateful.
Grateful.
Yes.
103. Bhagirathi.
Lord, affidavit filed before the trial court, my lord. 103, my lord. Judgment.
Why you call this matter? No, the respondent has asked for time in this. And I said that matter will not reach. He asked for time. We'll see. Let it be there in the list. No, passovers.
Passover matters. List number 1, serial number 13. List number 1, serial number 13, Passover matters.
Nothing for the petition in this case, my lord. My lord's office has raised an objection regarding the maintainability, my lord. My lord, the thing is that, my lord, it's an order passed on not on merits. It's dismissed for default, my lord. Non-appearance of the parties. Application has been dismissed, my lord. My lord, an ex parte judgment has been filed in suit for specific performance, my lord. I was not a party. an objector application has been filed by the present petitioner before the trial court, my lord. That application has been dismissed for default for non-appearance, my lord. For that, my lord, recalling an application under section 105, 106, an application has been filed by the before the trial court, my lord. Trial court has declined to entertain that application, my lord. Because of the marriage of the petitioner, she could not able to attend the matter, my lord. A day's accommodation is given, my lord. We'll address our arguments, my lord. Let the trial court
No,
be,
about the maintainability first, you've answered to that.
my lord.
How it is maintainable?
Regarding the my lord, I have some coordinated bench of Bombay High Court has been held, my lord. Writ petition is maintainable regarding instead of RFF, regular first appeal is not maintainable. If at all it amounts to judgment decree, that amounts to finality, my lord. If at all object application decide on merits, the case on hand is not been dismissed for on merits, my lord. It is dismissed for default. May I take, my lord, to the impugned order format, my lord. Internal page 53 format, my lord. 53. May I read the order, my lord? This court had granted the last opportunity to the obstructors.
Whatever it is, a dismissal.
Please, my lord.
Dismissal, it's an order.
It's not for on merits. My submission, my
No,
lord.
whether it is merits or not, on an application under 2197.
Please, my lord.
Whatever it is, it didn't say the dismiss for default.
Please, my lord.
Dismiss it said.
My humble submission.
Question it wherever your there is a regular appeal lies against this.
My humble submission, my lord. Coordinated bench of Bombay High Court has relying on the apex court judgment has clearly had that it is maintainable. That was the view taken by the. May I take, my lord, section itself?
It's maintainable. How it is maintainable?
Because it was not considered on the merits of the case. Objector application has not been considered on the main merits of the case. It may dismiss or default. If the application dismissed or default, it is maintainable. That was the view taken by the. Please, my lord. So judgment passed on 6th August 2025, my lord, by the Bombay Judication, my lord. May I take, my lords, to the in the same similar set of facts, my lord. In the execution petition, we have filed the objector application. Kindly peruse, my lord. Preliminary objection has been raised in that case also. Paragraph number 2, my lord. May I read for my lord? The present
number.
Paragraph number 2, my lord. By the audit date so and so, notice for final disposal so and so was issued. When the petition was taken up for final disposal, land counsel for the respondent raised a preliminary objection that the petition would not be maintainable as the impugned order is appealable under clause so and so of CPC. Land counsel for the respondent relied on decision of this court in the case of the so and so to support his submission. He submitted that the provisions of Rules 105 and 106 of Order 21 of CPC would apply to the restoration of the execution application. He thus submits that once the execution application is dismissed and the restoration application is filed, the same would be appealable in view of clause so and so of CPC. He submits that in the decision of Dattatreya Jog, it is held that Rules 105 and 106 of Order 21 of CPC apply for restoration of execution application. May I pause here for a moment? Kindly peruse section 105, 106 of CPC for a moment.
Let's complete.
I'll complete, my lord. Please, my lord. Third paragraph, my lord. Land counsel for the petition submits that the impugned order was not passed under the application under 106 of the Order 21 of CPC. He submits that the execution application was dismissed in default on 1st September 2014. Hence, the application for restoration was filed under section 151 of CPC. Case on hand also, my lord, we have filed our application for restoration on 151. He submits that the learned judge refused to exercise inherent power under section 151 of CPC for the restoration of the execution application. He further submits that neither the execution application was dismissed under Rule 105 of 106 of Order 21 of CPC, nor was the application filed under Rule 106 of Order 21 of CPC. Therefore, according to the learned counsel for the petitioner, the impugned order would not be appealable and the writ petition is therefore maintainable. The order passed in the very same case, my lord, it will further continue, my lord, to examine the preliminary objection. My lords, we got it, paragraph number 4 in the same judgment, my lord. Exact verbatim order has been passed in my case also, the case on hand.
Where is that impugned order?
the present case on, my lord. This is verbatim, please, my lord. It's in the internal page. My lords are asking for the dismissal order, my lord, or the present impugned order, my lord. Present impugned order in internal page 69, my lord, annexure H.
Yes. Yes.
May I take, my lord, internal 53, my lord? The verbatim order has been passed in the judgment which I am relying on. That is exactly the verbatim order, my lord.
Yes.
Please, my lord, may I take, my lords, to the earlier order, my lord, internal page 53, format, my lord. I just read out, my lord, regarding the impugned order passed on 28/3/2026, my lord. It's a verbatim order passed in the present judgment relying by me, my lord, passed by the Honorable Bombay High Court, my lord. Opportunity would have been given for the objector when the application is dismissed for default. 30 days limitation period is prescribed for restoration filing an application under 105 and 106 of CPC. Similar set of application has been filed by the present petitioners.
No,
Seeking
the court had
recalling-
granted you time on 15/5/12, 17/12, 19/12.
Lord, because of the
8/1,
petitioner's
9/1,
marriage,
23/1, 21/2, and on 27/2.
because of petitioner's marriage, I produced the invitation card also, my lord, on the
Why
same
the
day.
advocate is not, she has not engaged the advocate.
They have engaged, my lord, because of instructions, because from
He's
the.
also attending the marriage.
That's difficulty, my lord. One of the relative of the petitioner is the advocate. That is the difficulty.
Marriage, it's 5/12,
My lord, impugned order kindly produce, my lord.
23/1 and 27/2.
Lord.
3 months. 3 months.
Yeah.
From 5/12/2025.
Performance of
27 to
marriage, I have
20
produced the invitation card also, my lord.
No,
Kindly
forget
produce.
about the marriage card.
Please,
Forget
my
of the, what about 3 months? If it is, if there is marriage, not necessary that she should not appear before the court for 3 months. Look at page number 72.
Please, my lord, dates has been given, 5 dates has been given, my lord. That problem is that, my lord, in the impugned order, my lord, impugned order has been passed. The marriage is on 21 and 22 of February 2026, my lord.
When is the marriage?
21 and 20. two of my inflation guardians I have produced, my lord.
Then what are you doing from, what happened from December 5th? December 5th. 512 you saw time 1712, 1912, 81, 91, 23:1, 21, then 20, 21 to 26 marriage we can understand. Then what about all other dates?
Difficulty is that, my lord, without lack of instruction, the advocate could not able to appear before that regular. Lack of instructions before the court, the advocate who has appeared before the court, trial court, she could not able to instruct him properly. That is the difficulty. She could not. I am only seeking a day's accommodation, Lord. I address my arguments on.
We don't know what will come on that date.
That is that I'll undertake, my lord. Any date fixed by this honorable court, my lord. I will put me on terms, my lord. Any cost also, because, my lord, because of the mistake committed to advocate, party should not suffer. I am undertaking that, my lord.
What mistake the advocate has
The
done?
non-appearance of the advocate. My lords have asked why nothing prevented for the advocate to address as argument appear before the court. Because of mistake of the advocate, party should not suffer. My only concern is that, my lord, an opportunity has been given for her. Let her address arguments on mail. An opportunity put me on terms, my lord, and cost may be imposed. I am considering that on behalf of my client also. An opportunity has to be provided for her. Let her put forth her claim before the court.
Issue notice to the respondent 1 and 2. Petition is permitted to take out hand summons on the counsel appearing with the respondent and file a memo to that effect by 15th of June. List this matter on 16th. The office objection with regard to the maintainability of this petition is overruled. The petitioner has relied on the order passed by the Bombay High Court in WP number 10593 of 2023 in case of Rahul Tatyabai Jamdar versus Narayan Vishnu Nalwade dated
Number 19.
what is the date of this
My lord,
order?
date of judgment is, my lord, 6th August 2025, my lord.
25. Yes.
Meanwhile, not to precipitate, my matter is listed on 6th, my lord. My only till
Let them
extent
come,
of
we'll
hearing,
see.
till extent of hearing.
Let them come, we will see. That's why I have given a short date, 15.
Cell number
Please, my
19.
lord.
19. Patil Dayanand.
For the petitioner, my lords.
Yes.
My lords, pray for a short accommodation, my lords. Pray for a short accommodation, my lords.
Why?
The senior is unable to appear, my lords.
I heard it. There is no illegality with the order. That petition has to be dismissed.
My lords, there's a similar matter, my lords, kindly. There's a similar matter, my lords, kindly post it together next week.
List along with that as part heard on 10th on the top of the list.
Wait.
Yes.
Cell number, list number 2, serial number 2.
That the cross-examination can be completed in one day. Huh? How many days are required? I have seen that. I'm asking if he comes to Bangalore, how much time it will take? I'm asking.
He is cited at PW2 and PW1's cross examination is set on Saturday.
Is DW2?
I did, I'm sorry, I stand corrected. DW2 and DW1's further cross examination is posted on Saturday, coming Saturday. Thereafter, depending upon their convenience, the High Court may fix a date for their affidavit evidence.
That's what, whenever it is, whenever the turn comes, how much time it requires?
157 exhibits I have marked, and is a crucial party in the suit. These two laws are in several briefs, and I do not know whether you associate whether there is a release of this on the week or interpreting the rules not in place.
Take that. Yes.
The present application works is not suddenly by invoking the rules of Honorable Court. The,
This is what is extracted in the order.
Exactly.
I've seen that.
Therefore, this order of the trial court was under 227. Very difficult. Trial court is clear with that. Now they are not made out in the extraordinary case. Two documents they are produced along with identity. They were not made available in the requisition first. Secondly, a document which was not before the trial court is also produced along with the requisition. And those documents do not really make out any case of hardship for him to travel from Delhi to Bangalore. And in fact, we have gone on record saying that he has traveled abroad also. And there is no material with regard to that.
They placed they placed a document to show that he has not traveled. That's
Yes,
what
ma'am.
she's saying.
Yes.
They have given to us
It's a
passport
passport.
copy.
It's a passport copy is there along with the petition itself. Petition itself. So it's at page number 275, my lord.
For this honorable.
Yes, ma'am.
For this honorable that is made available.
My lordships, it was a
Trial court.
it was a statement. We were not given an
Find all the
opportunity.
documents like that.
No, my lordship. The problem was, we were not given an opportunity to, because once they filed objections, it went for arguments.
Anyhow, whenever I'll say 3 days time is required and it shall be completed at one go.
My lordships, it's very difficult for him to travel, not only travel, my lordships, because he can't sit. Because I produced a memo along with the court, along with the medical records, my lordships. I produced a memo on 22/4, my lordships.
Then how will he appear through video conference?
At least in video conferencing, he can stand, sit, but traveling for 2.5, 3 hours and, coming to the airport, coming back, coming to the
Anyhow,
airport in Bangalore.
Whatever the medical records you have placed.
Yes, my lordships.
And what you are submitting, that can't be, there is no nexus between both.
No, my lordships,
Because
there is a nexus.
by that document, you cannot say that he cannot travel.
My lordships, the medical records which I had produced before the trial court, I cannot produce a certified copy, my lordships. So I produced a memo on the last date of hearing, that is on 22/4. I produced before this honorable court. A copy I'm giving, my lordships. It's not that something which it was it was a genuine reason that he cannot travel, he cannot
Might
sit.
be a genuine reason for you, but they have to establish their case by cross-examining you. That he can't be deprived of.
My lordships, if they have fear that the witness will be tutored or he will be a court commissioner may be appointed, my lordships, or if they want to send one of their juniors to Delhi to be with the DW2 at the time of cross-examination, we are ready to pay the expenses, my lordships. Whatever strictures this honorable court wants to pass, terms and conditions, we are ready to abide by them. And the cost also.
That is true. It's not a matter of right. It is before the court. Now it's for the court to decide. Yes.
Because first, have a discussion with us, take our consent and then make an application. That is what the rules are saying. The rules are interpreted.
Anyhow, you're not, it is not acceptable to you. No, let's not go back to that.
The reason I have marked 157 exhibits in my evidence. And some of the documents are exhibits are being confronted to the present witness. And similarly, they were together when the event happened, cause of action started. Therefore, this witness also, I mean, on all those documents, becomes totally impractical from the VC.
No, forget about the VC. Forget about the VC where there are cases when the witness is not in a position to come to the court. How the witness is examined before these rules?
Through court commissioner, my lord.
Let him say.
Let them make an application then on the minutes. We have been addressed the arguments.
And what again, another application for that? Ultimately, he wants it, he doesn't want to come to.
They must become a case for the provisions of the CPC also provide for that. You must make out a case. If they are able to make out a case and we are given opportunity, so suddenly we will assist the trial court. I must submission this order is totally in accordance with the rules and the interpretation of the rules by this honor. And therefore, they don't refer to some irrelevant provision of the CPC and make this application. Even after they come to know the rules, we argued this matter before the court. I'm citing the rules and the ruling. And they're not, I mean, not even a single provision of the rules are complied with like that.
What are not complied with? What is not complied with it, they have not asked for your consent. And apart from that, what they have not complied with?
And what is the nature of prejudice which is causing to the cost of me? I am the plaintiff before the court, I paid full court fees, and I need to establish my case. Therefore, my response submission is, this all is not here, is intact, keeping it intact. If they are, they want to file an application for other privilege, I cannot come in the way.
Yes.
My Lordships, I would like to present a few precedents of the Honorable Supreme Court and.
Yes.
My Lordships, in this writ petition, the Honorable Supreme Court is urging upon the High Courts to use technology, my Lordships. May I draw my Lordship's attention to para number 14 at page number 6. Yes, my Lordship. And then I have also produced a list of citations.
Technology has to be used.
Yes, my Lordships. That's what we're
depends-
relying on because
depends upon the facts of the
then
case.
also, my Lordships, we
Apart
have.
from this,
They are relying on a judgment of this Honorable Court, TGV Prasad. My Lordships, in this case, there's been enormous amount of delay. But, by a latest judgment in writ petition number, criminal writ petition number 20095/2023, the Honorable High Court has allowed we have given it, sir, already, allowed cross-examination of the witness, though he was in Bangalore itself because they did not want him to travel to within the state itself, my Lordships. That citation also I have produced, my Lordships.
take that.
I'm not too sure about the second ruling.
So we gave you on the last date of hearing. Sorry, sir. My Lordships, can I take my Lordships to page number 13, my Lordships, para number 7.
The rules were relied on. There is no much.
Yes, my Lordships.
discretion in this.
So in this case, my Lordships, though the parties were within the state itself, the cross-examination in a criminal petition has been allowed.
Case, the only point is whether why the petitioner DW2 cannot travel to.
The reason is only very because of this advanced stage and medical conditions, my Lord. That's the only reason that we are.
3 is not an advanced stage.
Sorry, my Lord, 75.
So many advocates practice.
That may be for legal
75.
profession, my Lord, but not for others.
Oh, he is the CEO.
Yes, my Lord, but he is now not so active. But because of his medical conditions, he is not able to travel. He is not able to sit.
What are those medical conditions? You
My Lord, I've given the this.
That is not a medical condition where the person cannot travel.
My Lord, we have already produced a medical certificate also, my Lord, stating that he can't do a long distance travel at page number 296. 296. Yes, my Lord.
I've seen that.
It's the only reason why we are asking is because of his advanced age and medical
Only
condition.
this, as I said in the starting also, whenever 3 days, I'll ask them to, complete the ETEGO, 3 days, the cross-examination shall be concluded.
Lord,
Yes,
it will be
I'll
very difficult, my Lord, considering his age and also, my Lord, they have taken 5 years to come to evidence. And another thing is, my Lord, they have changed 5 councils, my Lord. Yes, 5 councils, my Lord, and they have completely protracted the proceedings.
Disposed of. Completed in 3 days. Yes, next.
Cell number 8.
Leadership 3 days continuously.
Or different.
Yes, whenever a date is fixed, continuous 3 days, it should be concluded.
That might be.
That I'll dictate. There are so many matters in the list. Yes. Yes.
My Lord, we are willing to serve the affidavit evidence in advance so that when he comes, So let them start the cross-examination, my lords, because, on that pretext, they should not, that.
Court will fix a date. On the day you come,
Mm.
from that day, I'll direct the court to take it up 3 days and he should
Continuous.
complete it.
3 days continuous. Oblige me.
Yes.
Serial number 8.
Appeal for petitioner, my lord. My lord, the petitioners have filed a suit for partition, my lord, where the trial court granted, my lord,
Yes.
interim order directing not to alienate the property, my lord. That order was reversed by the first appellate court, my lord, by substituting new view, my lord, and also by interfering with the decision of the court, my lord. Now, kindly see, my lord, the para number 6 of the written statement, my lord. The defendant conceding that is the ancestral property. It's the page number, my lord, 31, para number 6,
First
my
of
lord.
all, come to the order in IA.
Impugned order, my lord.
Hmm.
Can you refer before that, my lord, can you refer trial court order, my lord?
That's what. I said trial court order.
Para number 11, my lord, ink page number 46, my lord. In support of their contention, the plaintiffs have filed an array of cogent and credible documents, including the genealogical tree establishing their lineage from the common ancestor Siddhappa, handwritten RTC reflecting entries in the name of their grandfather from 1968-69 to 1980-89, computerized RTC evidencing the current khata in the name of defendant number 1 and 2.
Where are you reading?
Well, page number 46, ink page number 46, para 11.
Yes.
In support of their contention, the plaintiffs have filed an array of cogent and credible documents, including the genealogical tree establishing their lineage from the common ancestor Siddhappa, handwritten RTC reflecting entries in the name of their grandfather from 1988-68-69 to 86-89. The computerized RTCs evidencing the current khata in the names of defendant number 1 and 2. Mutation extracts tracing the chronology and nature of changes made in the land records. Incumbent certificates and the impugn deed dated so and so, which form the basis of the contested alienations. A perusal of these records established beyond any doubt that the root of the
Suit is for partition.
suit is for partition, my lord. Well, the first appellate may continue, my lord.
What is the relationship? It says defendants have not produced a document.
My lord, I am the purchaser, my lord. I had produced, my lord, enough number of documents stating, my lord, how the severance of,
Purchase the property from whom?
my lord, the first sale happened in the year 1996. My lord, the family members, my lord, would sell it in the year 1996. My lord, then, my lord, it is sold in favor of defendant number 3 in the year 2021. The user of the land is converted to residential purpose. My lord, I purchased the site. And my lord, when I say purchase the property, when, my lord, I am going to develop the property, my lord, few persons from the family, my lord, would make a half-hearted attempt. All the properties of the family is not included. My lord, all the parties are not included. The family owned, my lord, nearly 15 acres of land. Only 21 guntas of land which is sold, my lord, is made the subject matter of the suit. Concerning that, my lord, they wanted to seek a restraint on alienation. The first appellate court, my lord, appreciated. In fact, my lord, when some of the properties were acquired, they went, my lord, said that it has fallen to their share. They have, my lord, got compensation, my lord, at the hands of KADB to the extent of 5 crores. My lord, those properties would never be made subject matter of the suit. Specifically targeting the purchaser after, my lord, 1996 is the sale. 2024 is the suit. That is where, my lord, the appellate court, my lord, would
Reading the
interfere.
court, my lord, kindly appreciate, my lord. There are 14 properties acquired by the Dottimaya, my lord. Wherein, my lord, the 4 properties under litigation and the 3 litigations, my lord. Can you produce that plain copy, my lord? And the remaining 10 properties, my lord, have been acquired by KDB. Wherein, my lord, compensation not only
So
received by the
let us understand this finding of the trial court. More significantly, the defendants have not produced a single document to demonstrate that they are the exclusive
madam.
owners of the suit property. There is an absolute depth of any evidence from the defendant that could validate the chain of title claimed by them or establish their right to sell or subdivide the property. The absence of any such documentation severely weakens the defense and affirms the prima facie validity of the police claims. What is this for finding?
The trial court.
Defendants are relying on a document to say that they have purchased the